driving financial mention. Rate of fill of 2015 mile. This matter may have taken up in it. Another matter, double PC. So fiction before this system since 2012 matter relating to engagement of subsidiary money. The loan terminal was pleased to dismiss my case, refer the number, and refer the date money. In otherwise, one RB referring date and dismiss
Criminal appeal my lord for bail my lord. It is appellant my lord more than 17 years.
From the year 2016, your lordship has already heard this matter.
Criminal appeal 2015.
Were you in a hurry? Yes, sir.
Jail.
Has he mentioned why you collected him?
By order 13 June 2025, the Honorable Court of this Honorable Court of the matter may be listed, and the applicant was
the matter has been
listed.
No, what is that matter?
Since we need deed petition against the cattle.
What is the prayer?
My prayer is that the applicant was retired from service 31/2014 on his superannuation, but till now he has not received the house rent benefit.
House rent.
House rent benefit.
What is the urgency in that?
No.
Retired house rent benefit is yes.
Jail criminal appeal my lord for bail my lord 2023 matter.
For bail, my lord. Criminal appeal for bail. Criminal appeal for bail.
Criminal appeal for bail.
Criminal appeal.
No, you don't give it. File the memo before the clear. Yes.
My lord, criminal appeal for bail. Criminal appeal for bail, man.
Pardon to mention you not see this honorable court has sent this case for mediation, but it is unsuccessful. Ma'am, this honorable court has sent this case for mediation, but it was unsuccessful. The matter is related to non-payment of interest.
Finding the mediation.
It was unsuccessful. The bank
Please give it.
did not incline to pay
Yes.
the interest.
Sir, it is retirement benefit, sir.
Yes.
Give it before the
Give
DR.
it before the DR. Yes.
From the lead mail, item 28, in a matter relating to pension of a scientist mail.
No, we are going serious. Why are you making answer? You want adjournment or what?
No.
Then wait.
Taken up mail because
Yes.
senior advocate of Mr. Behra is appearing in it and it you can try to take up 12 feet.
Let's see that. Yes. Call the matter.
May reach. So, to discuss for bail.
Give it.
Supplemented Delhi. First up, item number 1.
Item 1 as per the order letter 39/2025.
Yes.
As per the order letter 39/2025, instruction not come. Can it taken 2 weeks after, man?
My land has filed a counter affidavit.
In second case,
Second case, one common judgment was passed. This is with regard to
First case he has not taken.
yes, the common judgment was passed. My only understanding, my lord, I have been placed below the status when I approached your lordship. I approached as a status as a casual employee. Now they are not giving that. My salary has not been paid.
Yes. And that miscase copy has not been solved on us, madam. IA number 18049 of 2025.
Memo of citations also Supreme Court decisions.
I have solved it. You say that IN number 14211 of 25.
Yes.
That application copy has not been solved on you.
The second IA, madam.
Where is the second item?
1805025 for appropriate direction.
Yes, madam.
I've got the receipt.
In second case, madam. In item number 2, IA number.
Item 1 and 2 are connected.
Same matter. Similar matter.
No, it's all right, but you are supposed to obtain instruction.
Madam, regarding
Both cases.
vacancy and regular question.
So you want some time?
Madam,
Yes.
want some time.
Let me pay our salary, my lord. We are not paying salary. And we have been insisting to come through a service provider. So when you 23 or
10 days time, madam.
10 days.
Madam.
So today is 19th. We are keeping on 1st December.
Madam.
Yes.
No further adjournment will be.
My lord.
There are applications.
What is your good name?
Amit Kumar Shah, my lord.
Item number 1, Mr. Amit Kumar Shah,
My lord.
Land and Central Government Council,
My lord.
submits that as per the order dated 3/9/2025, he has yet not obtained instruction, and the matter may be taken off after 10 days. Mr. Mishra and counsel for the petitioner is present. Raised this matter on 1st December 2025. Instruction be obtained in the meantime, and the matter to be listed along with item number 2. Item number 2, where Mr.
Last two.
Senior
Ajay Kumar Rai, Senior Panel Counsel, is appearing. Also, Mr. Mishra is there. Okay, same order was passed,
My
and both are stenographer.
Yes,
Both are
both are
stenographer.
stenographers. There are an advertisement in
No,
2013.
we know that a detailed order has been.
Yes, Mr.
Yes.
You have occupied the road. Direct them to at least pay their salary and a
Sir.
very paltry amount we are getting.
No, they whatever days you are working, I think it is 7 to 10 days.
7 to 10 days,
7
they are
to
not
10
even
days
paying. They are not paying. June, July, this order was passed in July
So why
2025.
are you not paying them for those 7 to 10 days? So the regularization matter is different matter.
Now we have to
But
take
the days when they are working,
we have to take instruction regarding this matter. There is no instruction whether payment is made or not.
Mr. Mishra and counsel submits that even though every month the petitioner used to work for 7 to 10 days,
Yeah,
na?
7 to
Since July 2025 or 24?
2025.
2025, they have not been paid any remuneration. Land Council for the Union of India also took some time to obtain instruction as to why the amount has not yet been paid. If the petitioners are working for the aforesaid period, as stated by Mr. Mishra.
We have been working under this service provider from August
That is
to till today. So they are paying very paltry amount. What I was getting, that is not being paid.
Well,
That's my
all right. In the application is pending.
Yes.
We need not say anything.
Hmm.
Let them-
That may be indicated. From service provider, they are giving only very
It's a
paltry.
separate issue, madam.
We are
Yes,
not dealing
item
with the
number 3, yes.
Item 3.
That are challenging the order dated 8 January 2025, passed in OAF 7/6/2023 by the Central Administrative Tribunal of Kottaka Bench, Kottaka, so far as the interest and order dated 18/8/2025 in OAF 50
Who is appearing for the Union of India?
Can be possible.
Hmm?
Item 3 can be possible.
Sir, it is a very urgent case, sir. Sir, while the
Allotting council is that should be possible.
The prayer was to pay interest on the gratuities
yes, sir.
at the rate of GPF interest for the delayed period from 2014 to 12. So that was stormed down or what down? Come to paragraph number 9. Paragraph 9. No, you come to paragraph 7. Paragraph 7. Read.
Sir, due to passment of charge sheet, the applicant is entitled to get the interest from the date of the retirement.
You read paragraph number 7 of the impugned order.
Paragraph 7. I don't understand.
Paragraph number 7 of the impugned order.
Sir.
Are you not able to follow?
No, sir.
You follow?
You have challenged an order.
Yes, sir.
Which order? You have?
Sir, order. Sir, order of the OA 766/2023
Which
for
annexure?
the interest part and OA
Mr.
for
Council, which order you are challenging?
sir annexure 203.
Annexure 2 and 3.
Sir.
Come to your prayer portion.
Yes, sir. Sir, my prayer is the honorable court may graciously please to issue on call for assessment to show cause as to why the order dated 18/2025 annexure 3 passed in OA 50/2025
So where is that prayer that you are challenging annexure 2?
annexure 3, sir.
Oh, you just said that you are challenging annexure 2. You do not know what you are challenging.
Annexure 3, sir. Sorry, sir. Annexure 3.
What is annexure 3?
Annexure 3, sir, last page. Page 30.
Why your prayer was torn down by the learned tribunal? Come to the relevant paragraph. Paragraph number 7.
Paragraph number 7. Sir, while the
Read paragraph number 7.
sir,
Why are you looking at us?
You have not prepared that take time. Why are you taking
due
that
to
risk?
passment of a charge sheet, the applicant is entitled to
That's
get
not paragraph number 7. You are not prepared. Urgent matter is urgent. Yes, next.
Item 4.
order.
Yes, item number 4. Item 4, my lord.
This order of the tribunal is a composite order in 2 way has been filed and common judgment has been passed. In another way, that on double PC number 32446 of 2025 has been filed.
That's not listed.
Let me call
Yes, I have already appeared and filing a counter.
Let that also be listed.
Can you give that number?
my lord, 32446. I am giving.
Mr. Vishwajit Maharana, Senior Panel Counsel, submits that this writ petition is connected to WPC number
32446 of 2020.
And
Same
Opposite order
as
has
the in order which is challenged in both the cases are one and same, right?
Yes, ma'am.
Mr. Rothal and counsel, who is appearing for the opposite party, also does not dispute the same. And submits that in the said case he has already.
I am appearing. I have already other case.
You have already entered appearance. No?
Already
Has already entered.
but that copy has not been sought and
Who's the secretary?
Karata.
Acha. However, he submits that the copy of the writ petition has not been served.
I will
Mr. Maharanal and counsel submits that he in the meantime.
in that case, my lord, Mr. Das is appearing. I intimate him to serve.
He submits that Mr. Rothal.
Oh, sir, in petitioner,
He will take steps in so that the writ petition copy is being served on the learned counsel for the opposite party. List this matter with WPC number, NASM number. Answer.
My long friend Varana may intimate Mr. Das.
I'll intimate. And my friend is filing
You want it on Monday or on some other day?
26 years.
26th. 26th.
You're filing response.
I'm filing counter. I have already
You filing
in
the counter so that
in this matter.
in this matter.
No, in this matter, please file. That will be scanned. So if you file here,
There I will.
yes.
Item 5.
26,2025 हुई ये जो आरो रिपीटिशन दा आणला सेटा रिपीटिशन कंप्लीशन. Yes.
Item 5, I am appearing for 1 and 2 for the State Bank.
Who is for the petitioner?
Of course, that was because the single judge. Some interim order was passed. But, subject to payment appeal of CA.
you are challenging option sale.
No, I am the loanee matter. I avail a
No,
vehicle.
the prayer
What
is
are
to
you challenging?
prayer is to challenge that auction sale notice.
Yes. Yes. Interim order was, some order was passed. It was CA.
Where?
Running page at page 41.
No, this is coming for the first time. Where is
Yes,
the question of?
No, earlier it was before Justice Singh. It was
Earlier.
before Justice Panigar at single bench. 31091 of 2024. Page 40.
Yeah.
And the page 41, 11 portion, para 7. Now, counsel for the opposite party bank submit that the total outstanding dues amount is 4,70,085. In view of the foregoing and considering the submissions made by land counsel for the parties, this court direct the prisoner to deposit sum of rupees 4,70,805 along with applicable interest, if any, OP Bank by 5th February 2025. Upon such deposit, OP number 2 bank shall release the aforementioned vehicle in favor of the prisoner. In the event the prisoner fails to deposit the aforesaid amount within the stipulated time frame, opposite party bank shall be at liberty to proceed in accordance with the law.
Yes, that order was passed way back in January 25.
Yes, my lord.
You might not have paid, so
That is
therefore they
the
proceeded.
auction sale notice was issued on 4/10, and you have alternative remedy. Why will you entertain?
When OA is pending before the
Oh, wait. Wait, file is there.
In view of the
What
financial
is the number,
stringency,
please?
OA 273 of 25.
273 of 2025.
Mm.
This man has filed.
Yes, ma'am.
Have you mentioned it?
No, the bank has filed against the
bank. What he mentioned.
Raise all these points there.
Have you entered appearance in that?
Yes, they have entered it. Yes.
I was just a Bina filed the one way.
Wait. That's not a what is the prayer of the bank in that way?
For recovery of sum of rupees 49 lakhs or
The writ
May I pray
petition
that
has been filed.
may I pray that due to financial stringency, I could not able to deposit it. One
The
chance.
11th single judge has given you indulgence, let it in compliance.
And one more thing,
Then face.
I should have sought for some time since the order was passed
No.
in my presence.
You want to
I could
withdraw
not
and
able
do
to
whatever.
deposit the same.
You
I
see
should have
the-
asked for some time to
the date
deposit the
was-
same.
The
Yes.
date was fixed.
Yes.
5th February 2020.
Yes, that is it.
Suppose, let us say you had some financial difficulty. You could have approached the land single
Single
judge by
judge, yes.
filing an interim
Yes.
application to extend that time. Did not do. So they went on for auction sale.
no, he filed a writ petition that was withdrawn with payment of cost.
The petition has been filed by the petitioner, Srimati
May-
Godavari Diriya.
May I pray for one thing, my lord? May I pray for one thing, my lord?
Yes.
That the single bench was pleased to dispose of same. May I be permitted to file a IA seeking for some time so that
So and so. It is brought for notice by Mr. P.V. Balakrishnan and counsel appearing for the opposite party number 1 and 2. That at the instance of the bank, OA number 273 of 2025 is sub judice before the London DRT pattern. Moreover, even though the petitioner earlier approached this court in WPC number
31091.
31091 of 2024 and by the order dated 21/1/2025, the petition was disposed of, directing the petitioner to deposit a sum of rupees 4,70,805 along with applicable interest with the bank by 5th of February 2025, but the same has not been complied with by the petitioner, nor any applications has been filed before the Lawrence single judge to extend the period of deposit. And for that purpose, the bank has already taken recourse to the auction sale notice. He further submits that in view of the development made in the meantime, and since alternative remedy is available, this writ petition should not be entertained.
May I pray for one thing?
The land counsel for the petitioner, however, submits that he may be given liberty to file an interim application before the London single judge in the disposed of writ petition to extend the period for deposit. We are not expressing any opinion on the same since alternative remedy is available. The writ petition is disposed. Yes, next.
Item 6.
Yes, Mr. Dwari,
Can the permit to withdraw to file better?
where is your memo? Mr. Sahoo, you are appearing. Mr. Puna Sahoo and counsel appearing for Indian Bank is present. Memo of withdrawal has been filed, which is taken on record. The writ petition is disposed of as withdrawn. Yes. Yes.
Item 7. Check item 7. May I pray for a passover?
Who is that? You have received the copy of the writ
Yes,
petition?
sir.
Okay. Pass over. Next.
Item 8.
May I please a lot.
Yeah.
Item number 8 and 10 are similar matters in which the petitioner have challenged the notice of sale that is under Annexure 8 at page 36, my lord.
Sell notice you have challenged.
Yes, my lord.
So,
The
same thing you go there. You are the
date has been
loanee.
Yes, my lord. Date has been fixed to 26. I am ready and willing to deposit 50% of the
Make
amount.
that prayer before. They are also knowing that you deposit all these things. The like on the same thing. The writ petition has been filed so and so, or so and so, and alternative remedy is available, disposed of, giving liberty to the petitioner. So same prayer in art
8 and 10.
disposed of. Yes.
So bless.
Item 9.
Mr. Swine, Vibhuti Bhushan Swine is not there. Pass over Karam. Yes, next.
Item 11.
Yes, Mr. Maji.
Kindly taken up one chapter, my lord.
Why? What is your prayer here?
In the interest of my client, I have done this matter.
What is your prayer? Sell notice you have.
Yes, my lord.
So if it is kept pending, what purpose? Rather you approach the, you are the loanee.
Yes, my lord.
So same thing. Disposed of. Unnecessarily. Yes, next.
My lord, in
Item 12.
item 8 and 10, my lord, my caveat was there.
अच्छा अपन ना ये
Again, 8 and 10.
अच्छा ठीक है. The land council, please give the name and आखिर ना सुबह for example for the opposite party, that is Indian Bank, है ना?
Yes.
Yeah, Lord. Mr. Delan, 8 and 10 रे तो ना लिख दे, हाँ? Yes.
Item 12.
Item 12, my lord, I am from the respondent bank.
What is
The last time also, appellant was not there.
Single judge.
It's a writ of file by the appellant praying for back wages. After the appeal, convictions have been
So it's a
settled in the
reappeal of the year 2015.
Yes, ma'am. 14
and delay condonation matter
there is also
notice has
delay.
been issued. Nobody is appearing, and 10 years have already passed.
Yes.
Let me know. None appears for the appellant. On the last date, that is on 23/9/2025, when the matter was taken up, on that day also, nobody has entered appearance for the appellant. It's a reappeal of the year 2020, 2015.
We got it. No?
Hmm?
Actually, he was good. Now, please. These people are.
The land counsel for the bank, Mr. Swine is present. The writ appeal stands dismissed for non-prosecution. Yes.
So my name may be
Like
yes, is fine.
Wahil Swine, Mr. Swine, Anand Chandra Swine.
Fine.
Yeah.
Yes. Obliged.
Item 13.
Might please, your lordship, I am appearing on behalf of Mr. Hara Prasad Panda. Due to ill health, he is unable to. Where is your file? Why are you coming without file? You should hold the file. Never come, never appear in the court without file. Okay.
Please.
And you should at least suppose we ask you that what is the prayer in this writ petition or review petition? What has been challenged? Can you say? The minimum thing is required that you should have gone through the prayer portion at least. Oh, nobody, your senior has asked you to take adjournment, all right, but your senior has not prevented you to go through the file. So that we expect that at least that much you should do. While coming to seek for adjournment, that you should do and also bring the file. We are not adjourning for any other reason. You have a genuine prayer, although we are adjourning. Do this much at least. What is your good name?
Ashish Kumar Meher.
Ashish Kumar
Meher.
Meher, Land Council appearing for Mr. Haraprasad Panda submits that Mr. Panda is not well today and the matter may be taken up on some other day. Please this matter. How much time he wants?
1 week.
1 week. 1st December we'll keep.
Well,
Okay. 1st December 2025. Yeah.
obliged.
Item 14.
Mr. Samarendra Patnaik, not there.
Still, we have to file objection to the limitation of 77. Some is contacted with the trade for some of the
Some other day.
Acha, non appears for the appellant, petitioner. Land counsel for the state seeks some more time to file objection to the delay condonation application. Put up this matter. How much time you want? First, place this matter on 1st of December 2025.
Item 15.
And for the loaning unit. This is party number 3 and 4.
So where is Mr. Divedi?
I am for bank P1 and 2.
No, you are all there, but the petitioner counsel is not there. What is the
Open-
prayer in this petition?
OP number 4 has
Issues of
been
sale certificate.
Issuance-
Issues of sale certificate.
sales at
Although
OP
the
number
four-
4 has been died. He has filed a substitution. So let him serve a copy.
No, this any matter is pending before the DRT.
Your Lordship, the OP number 3 and 4 have already cleared all the loan amount, Your Lordship.
Now, who is the petitioner here?
The
Auction
petition-
purchaser.
Petition or auction purchase.
Auction purchase.
Non appears for the petitioner. Learned counsel for the
Loaning, Your Lordship.
loading one opposite,
OP number 3 and 4, Your Lordship.
opposite party number 3 and 2. So also the learned counsel for the
Bank OP number 1 and 2.
learned counsel for the 1 and 2 and learned counsel for the 2 and so are present. Place this matter on 1st December 2025. Yes.
Next.
Item 16.
It's the state case.
State is the pit appellant.
No one is there. Yes, sir.
Yes.
State. Out of the state.
Who is appearing?
There was a direction to pay cost.
I think it appears on the note that cost has been paid.
But in the background, just tell us by the time.
The background is this. Well, the judgment of the tribunal is the subject matter of challenge. In fact, TPC was held way back in 2012 for 563 number of vacancies. And the rule 15 was governing the FIT, which is also still holds the FIT. There are 3 processes of recruitment. One is direct recruitment. The second one is induction. And so far as third is promotion. So far the present private opposite party for whom I am appearing, we have also filed a writ application challenging that, because we are inductees. And in fact, as per Rule 18, if how the promotion has to be given effect, that is provided in Rule 18. Now, those 563 vacancies, we are coming into the zone of consideration. Our case were considered, and we got the promotion because 5 we comes within that 560. Subsequently, another a 2 person filed before the tribunal challenging that another 263 number of vacancy, why it was not included. That vacancy are still available, why it was not included. So that during pendency of that application, many things happened. We have got the promotion, other thing. But the judgment was passed by the tribunal way back on 21/1/2014, but without including us as parties. So we have filed a writ application. My writ application number is 25911 of 2014 is pending. And sorry, 31996 of 2025. and so far Mr. Mishra, Gautam Mishra, he had filed independent writ application for the same persons. Those who have already got promotion, they have, because the interim order has been passed by the same honorable single judge, that subject to the outcome of this case. So now in the meantime, because the state has taken time 27 times, your lordship passed an interim order that let the DPC review DPC be called for, and the so far the seal, it will be kept in the seal cover without leave of the court, that will not be opened. This is the stage. At this stage, last time your lordship.
My lord, in this
My lord,
case,
may I submit?
the state
I was the original applicant before the tribunal. Well, there are 3 modes of appointment, as he directly said. Out of that, my lord, the rule is that the vacancies occurring in a year or anticipated vacancies will be filled up during that year. Then how is the promotion will be held? That 30%, 50% by the direct recruitment. That would be better if I place that rule.
my lord, on merit, my lord, I will go letter, my lord. I have filed a IA along with the last rate, my lord, imposed cost of 10,000 due to since the earlier order was not paid. That was already filed.
No, that is all right. That is paid, yes.
That is the IA filed to grant 3-month time to review DPC and kept in seal cover, my lord, because it will take of the year 2012. It will take some time. The
No, you on that day you said that it cannot be held or something like that.
Can't be held. Now they say that they need 3 months.
yes,
Now you,
because the CCR has to be collected from the concerned.
no, it's all right, but I think somewhere you have stated that it cannot be.
Yeah, I have written
you-
instruction that due to this reason.
Now
it's
you have
not-
said, have you served a copy of that interim order?
No.
Keep the copy. If you are
Yes.
showing the
Madam.
positive thing, then that's all right. Where have you stated that it will be done within 3 months?
My lord,
If all
What
the,
I am suggesting, that is for your lordship to take a decision whether or should grant or not. That's
no, just please have that
Yes.
petition at
No,
have that
I've got the copy. I will go through it.
I-
Lordship then called it.
IA number?
IA number, my lord.
Mrs. Rotho, have you got the copy? And
Both of us are
acha,
same
copy
side.
ta jo that dele.
No, Mr. Mahanti and myself are for the same side.
Where is that paragraph?
My lord, can have glance to paragraph.
Just show the relevant
Yes.
paragraph. Where have you stated that within 3 months you will hold that. Acha, conduct the acha. Prayer is that.
Yes, sir.
Five.
Petitioner has no intention to undermine the order of this, okay? Since this question of so-and-so to the one, okay.
Rupees 10,000 that change impossible to possible.
The language he has put, that should not have been put like that. That is the whole difficulty. And you also rightly said he could have filed an application for at least a modification, or he could have challenged it. But how could you do like this?
So, in view of this stand, what you want us to do?
Well, so far my stand is, your lordship may fix up this matter next week, any date.
No,
But in the meantime,
they want
that's right. But so far as merit of the case, in the meantime, your lordship can proceed and decide the matter on merit. They want the premium on the only question of the interim order.
No, they have already, Mr. Rautrai's client and Mr. Mishra's client has got the promotion already. We have no conflict with them. But what they are trying to do, your lordship, one branch out of that 3 branches was ignored. That is us, by way of promotion. So, on the plea that CCRs were not available by the time DPC sat. That is a question of records. I will satisfy from the records that CCRs were very much with. They are available and it was sent. But for some reason, that was not considered. Then
my lord, but other two branches were considered. What will happen now, my lord? They are trying, and if we are telling that promoters along with them, and that is what the direction is. Then we'll get into that same batch. Now these people, after having got the promotion, they want to have the seniority over us. That is why they are telling that no, they should not be given promotion and file independent writ application.
But in that DPC, suppose all these aspects will be taken care of, you might have no grievance after that DPC is held within 3 months.
Intercessionality will be there.
So,
Intercessionality will come.
Rakshiks are quite correct in that observation. The whole issue here is what is that the DPC should have taken in consideration of a larger number of posts. Larger number of posts. Jodi amo case setere consider the larger number of posts ame jaichantu.
Then your seniority would have come.
Kebala senior heitantu. They would have also come. We would have also come. We are seniors. What happened is because our case was ignored, so they entered into the cadre before us. So today they want to stop.
They march ahead you. They march ahead.
That's not correct.
So
that is
So Jadi aje review DPC holds and everything is seen and set back to that time. Of course, it will be implemented subject to result of this case. Then yes, a clarity comes. I would not deny that. A clarity comes, and the only issue would be left.
Then where you stand, that will be decided in the review DPC only. Thereafter, you open the.
Sir, I have something.
Review DPC will only decide whether we will be promoted
or not.
If there is any grievance regarding the intercessionality, we open for them to challenge in the
Sir, that is not the issue at all, sir. That is not the issue at all, sir. Sir, that the vacancy was, Mr. Mohan.
That is the issue.
Sir, so what I propose was, I don't want to call at this juncture because your lordship passed an interim order. Please, Mr. Mohan.
Mr. Rautra, please don't.
Please, Mr. Mohan, you are very senior.
Why you are telling that?
Mr. Mohan,
we are making.
Please.
Well, suppose, let us say, the DPC is held and it comes out that they are entitled.
Your lordship have passed order without leave of the court. The DPC, the shield cover shall not be opened. What I suggest, Lord,
let them complete it.
I don't stand on the way. What I am proposing to your lordship, subject to your lordship acceptance, yes, let them take whatever time. That's another part. Your lordship may grant, may not grant. That's a different question. But in the meantime, if your lordship will proceed to decide the correctness of the judgment of the tribunal, that will also start clear the entire issue.
Lord,
that is what I am trying to impress your lordship.
My lord, directed to conduct DPC and kept in ship only because of wrong submission, my lord. That they have not given promotion since 2012 and they have crossed 50 years. It mentioned in
we were alive of that fact that review DPC is held up because of this litigation going on. So we said that let the review DPC happen. Then we that was the idea.
By that instance of this that must be kept in seal cover. That was your lordship said. That is why
let it be held, kept it in seal cover.
But in the meantime, what prevented my learned friend to at least to argue the matter on merits? That is what I am saying.
It's not a question of merit.
Sir,
I am arguing. State is the appellant.
Sir, I have filed a writ application. That is why I pray that my writ application will be listed along with this, sir. And a batch of cases are pending, depending upon this.
That will be an intercessionality question. And our entitlement to promotion or not. That is not being decided.
Sir, Mr. Mohan, please allow it.
In a field cover.
Sir, please.
I have learned this from you,
sir,
Mr.
Yes.
Mr. Rautra and Mr. Mohanty, now till today, the intercessionality is neither before an issue before the tribunal nor before us.
Right, sir.
It is likely to come or not
after the
point. So the question that does not arise at all at this stage.
Sir.
So everything will be cleared once the state gives us information that DPC has been held and it has been kept in chill cover.
That's right. That is
For that purpose, they are seeking for 3 months.
That's right.
So all these issues which you are raising, intercessionarity, this, that.
Moreover, your writ petition will be heard by the division bench or single bench. That is
yes, sir. This is a judgment which is being challenged division bench. The judgment of
the writ petitions you have filed.
Sir, I have filed the writ application challenging the judgment, sir. My entire case is this judgment is a nullity so far the judgment of the tribunal is concerned because we
But
have
everything is contingent upon the outcome of review DPC.
No, sir. No, sir. That is exactly my point, sir.
Yes.
Review DPC also passed interim order. Please don't say yes. So far the interim order is also passed. That is only a rider is there. That will be without leave of the court. That will not be opened because you will also be waiting for the hearing of the main case. So this is after all introductory order.
By the way, we just want to ask you, you will guide us,
sir,
that suppose the review DPC is held and intercessionarity issue comes up, whether that is to be adjudicated by the tribunal or by us.
That is by this honorable court. That is
this bench means single bench.
Sir, that is by single judge. That is by single. Sir,
obviously,
sir, I am not on the question of seniority. I am on the question of the judgment of the tribunal, the correctest judgment of the tribunal your lordship is examining. In this case, at the instance of the state.
No, this subsequent issue which
sir, subsequent issue to sir.
So obviously, tribunal is not there. So such type of issue can be adjudicated by a single judge.
I can add, sir.
My brother is asking that
sir, that my reply is if your lord, if in the event they will succeed before your lordships, the application by the state and filed by us will be dismissed, then the question of seniority will come.
If we lose,
and if our writ application is dismissed, I admit that they will be treated to be senior. If your lordship is allowed the writ application, certainly will not that your lordship will not never interfere with this. This is the only thing.
Writ application is allowed. I have no right.
Therefore, I pray, also hear the writ application. You also grant time 2 months or 3 months, let them proceed.
That
There is no
process,
problem.
let it be over so that there is no further.
They want by virtue of the interim order to get the premium. That is the
No. We are absolutely dumb. We are not a fool that it will be not be open without the court.
I trust, sir, I will up to your lordship, sir.
আমি খালি প্রমোশনটা পাই
then I think why review DPC is important will come into picture is this. What is exactly the source of problem? The source of problem was that you should have put that entire vacancy as per the rule into DPC. So setebeloku na mu cadre re thile na tume cadre re thilo. So that cadre was subject to an illegality. And who is going to enter the cadre? What is going to happen in that cadre? Whoever comes takes is subject to that.
Right.
So review DPC re clear. So the previous samosa CCR kharab hoche. That is the end of the matter also then. So review DPC hai jab let
clarity comes, then we can decide this. That is what the whole idea is.
For review DPC of 2012. Will not take below 10 days time.
Sir.
They are asking for 3 months.
How many persons
total?
It is mentioned about 200, more than 200 persons.
What you have collected verified?
The
CCR छड़ा आउ कौन देखो?
मैंने CCR का तो
verification entire.
आउ कौन देखो दाम कौन written करियो?
ना
कौन नहीं पहुंचाओ के अपन जो सिनेमा पाई जन तो ସେଇଥିପାଇଁ ପଚାରୁ
different authorities ଅଛନ୍ତି different authorities ଅଛନ୍ତି ତାଙ୍କ ଠାରୁ ଡକ୍ୟୁମେଣ୍ଟ ଗୁଡାକ ଆଣିବାକୁ ପଡିବ
ଆଣି ସାରିଥିବେଣି already
ଥିଲା ତ ମାନେ ଆଉ ଥରେ ଆଣିବାକୁ
ମାନେ ତ ଥିବ ନା यार all in service
it has to be
sir
it won't take much time
sir
ଅଛି ନା ଅଛି କରିବିନି
because only one branch get out be considered na out of 500 there
for any other reason you are asking for a longer time tell us
sir the review DPC question utti kahi because of the judgment of the tribunal. Now your lordship is examining the correctness of the judgment of the tribunal, and your lordship has granted time. Let them proceed to collect. That's no problem for that. But if your lordship will hear the matter, and if your lordship will come to a conclusion, the judgment of the tribunal correct, then
लिखूँ IN number we are granting you 2 months time.
And we will fix a date. On that day, you come.
Yes, sir. And you also fix that date to hear the matter, sir.
IN number 20732 of 2020. This is an application filed by the state of Orissa with a prayer for grant of 3 months' time to conduct review DPC and to submit the same before this court in sealed cover in compliance to the order dated 10/9/2025. In paragraph number 5, it is stated in the interim application as follows. Quote paragraph number 5 and 6. Copy of the interim application has been served on the land council for the opposite parties who have no such objection for holding of the review DPC.
So, I am concerned because I think depending upon the judgment.
Subject as for the order of the this court dated 10/9/2025, but objects to the longer period sought for by the state to conduct such review DPC. In view of after hearing the land and council for the respective parties and going through the averments taken in the interim application, the date is fixed to pura pakka 2 mas douju tanku aji hochi 19 December 19, then January 19. January 19 के को बार पहुंची देखो
21st
January 19 होची सोमवार पहुंची
नहीं 21st January would be
21st
21st January
21st January 2026 है ना in the meantime the land council for the state shall apprise this court about the development made in the meantime.
My writ application is 2925.
The matter may be listed on that day.
It is made clear that no further extension shall be granted to the state.
So far, the hearing of the case
This is to come along with WPC number
31996 of 2020. I am giving the number.
अच्छा, Mr. आपको matter आसीनी क्या जी?
आसीनी ब्रा.
अच्छा, Mr. and senior advocate submits that this writ petition is connected to WPC number put of this matter, these matters along with WPC number so on and so on such and such date. Yes, next.
Thank you.
On hearing on that day.
On hearing that day.
On that day here.
Yes, sir. Yes.
Because we are taking care of
Yes, sir.
your travel itinerary also.
Invisible
invisible party
But Mr. You just advise your client, don't use such language while giving. This is not appreciated. When the order has been passed, you are writing that it cannot be complied with. This should not be the attitude of the.
And in the phase of that instruction, now you are moving this application. Just see. You are asking for 3 months. If it was not possible, then why 3 months then?
Language implementing. Understanding implement.
Whatever the language has to be,
The order is very clear, so it should be carefully cover and go. Yes, next.
Item 17.
Yes, Mr. Patnaik.
So final disposal. You
are not ready.
Then I am ready.
Who is for the other side?
I am appearing it through DC Miller. Okay. Oh, yes.
What order was passed last time?
No course of action to taken until adjournments are granted to me on my behalf.
There is an interim order dated 24/10/2025.
Yes, my lord.
What is that interim order?
No course of action. My OCB issued section 29 notice. take out the.
Place your case.
Yes, no. The short fact is that the petitioner unit took a financial assistance loan from OSFC minors for his unit minors.
When?
1990.
Where is your date chart?
No date chart.
Then how
Come
can
final preparation.
your final disposal matter?
Extremely sorry.
Prepare a date chart.
I'm extremely sorry, my beg apology.
Vote of submission in short, and if any
In short manner.
citation you are relying on,
Yes,
that should be maybe one or two
Make
pages.
comprehensive, 1 or 2 page mailers. I apologize. Maybe Friday mailers.
Prepare it. We can take up
Friday
it next
mailers.
week.
Today,
Mr. Patnaik and counsel for the petitioner is present and submits that he intends to prepare a date chart. So
written note of submission.
Written note of submission.
And
The matter
citation.
may be taken up next week. The land counsel for the OSFC,
Mr. P.K. Naik.
Mr. P.K. Naik, Prashant Kumar Naik is present through virtual mode. Is this matter? Aro Guruvar ne Budhavar ne astu.
Yes.
Anna?
Budhavar.
Yes.
So is this matter on
26th. Budhavar is what next time.
Is this matter on 26th of November 2025?
Yes.
Item 18.
With for the way WPC number 1337 of 2018. Yes, item number 18. Mr. Rothway, yes.
18 also, my lord, the final disposal. It has sent to the mediation and the mediation has been failed. And the last occasion,
Mediation report has answered.
already your lordship directed.
No, all right. We have noted down it that it is answered.
What I submit, my lord.
That is why both of you want that this matter to be taken up today, and that too on 22/10/2025 for final disposal. What is the problem today? Not ready.
Short note trial paper. Next 26.
Date chart not there.
Not there.
Date chart you want.
Date chart.
So same order for them, and it is.
Please publish your code, sir.
All right.
26 lakh.
Regents note कर दोगे, है ना? Mr. Maharana is there, and Mr. Rothwell and senior advocate is there for the opposite party. Say round 26/11/2025. Yes.
Item 19.
My lord. This matter will be prepared to this matter was declared there for yesterday. I'm praying for Passover and these two is on his way, matter.
What do you say?
Matter is Passover.
No, कौन है ला?
No, my lord.
Day before yesterday.
Yesterday, my lord, we fixed it today for final disposal. Their counsel was not present at that time, so that's why my lord. So that my lord, this is
yes.
The matter will be taken up.
No, the London Council is held up perhaps in some other court. He wants a Passover. Have you got any objection or you
No,
want it?
no, I have.
So please wait. Yes, next.
Item 20.
Item 20, my lord, South 3805.
Lordship, I need a week's time. We have already sent the draft for the department's approval. I just need 1 week's time. Within 1 week, we will file the counter.
Mr. Ashutosh Mahanti, London Central Government Council, appearing through virtual mode, submits that instruction has already been sought for filing the counter affidavit, and matter may be taken up after 2 weeks in order to enable him to file the counter affidavit. He lists this matter in the commencement from 8th of December 2025. Counter affidavit, if any, be filed in the meantime, serving copy on the Land Council for the petition.
Much obliged. Much obliged.
Item 21.
Well, at item 21, I have received instruction from the opposite party number 5, that is mining officer Katak Satri, my lord,
But the petitioner made Tahsildar Cuttack as the opposite party number 4. Here the impugned order was passed by the Tahsildar Tangi Chaudhar. So letter was issued to the Tahsildar Cuttack from our office. Tahsildar Cuttack intimated that this file is not. The petitioner has
So
to
the impugned
wait
order, who is
that
passed?
at annexure 8, my lord, page 158 and 159.
Impugned order has been passed by the Tahsildar Tangi Chaudhar.
Yes, my lord. The petitioner made party to the Tahsildar Cuttack. That's why from our office, the letter was issued to the Tahsildar Cuttack.
Tangi Chaudhar.
You wanted to at post Tangi Chaudhar, I have this mentioned.
Tahsildar
Cuttack. Just file an interim application to the learning council for the state has pointed out that the petitioner has challenged the order dated
23/5/2023,
23/5/2023 and 25/7/2023 under annexure 8 and 9, and both have been passed by Tahsildar Tangi Chaudhar. However, the said Tahsildar has not been arrayed as the opposite party. Instead, Tahsildar Cuttack has been arrayed as the opposite party number 4. The London Council for the petitioner submits that he may be given some time to file an interim application to correct the opposite party in the cost title. Name of the opposite party number 4 in the cost title. Mention it rightly in the cost title. List this matter. Next week. Is this matter on? We are keeping it on 26th, and you solve the copy on that day. It will be allowed, and you bring out that particular page also, page number 3. We will accept it, and then the matter will be regularized. Interim order to continue. List this matter on 26th of November 2025. If an interim application is filed for amendment of the cost title, the same shall be placed on record. Interim order dated 3/9/2025. 3/9. Your Lordship has directed the authorities shall not insist the petitioner to deposit. The interim order dated 3/9/2025 passed in IN number 4668 of 2025 shall continue till the next step.
Item 22.
Yeah, please. Order dated 23/9/2025. Notice to the party.
In this matter, I have a submission on the technical point of law. Because your lordships kindly see, this is a dispute for the raising of the electricity bill. So GIDCO is no way concerned, state is no way concerned. Only this is South, now TPCO, SOD.
From part affidavit to the affidavit effect, so that we can you will have a hearing on that, and if you say that it is
I have no submission, not maintainable.
Just
only he can go to the OES under
Yes,
section 140.
You are asked to file counter.
That is the reason. We can
Small
take
counter
up
I can file.
next week.
Only this.
Man, next week.
Next week.
Mahadil and senior advocate appearing for the
OP number 2 and
OP number 2 and 3 submits that the matter may be taken out next week, so that you can file a counter affidavit regarding that
maintainability.
Maintainability of the writ petition. କେବେ ଆଣିବା କୁହନ୍ତୁ? ବୁଧବାର
27.
ସୋମ ବୁଧ ଆଉ ଶୁକ୍ର ଏଇ 3 ଦିନ ଆସିପାରିବ। ଏଇ ଅନ୍ୟ ଦିନେ ସେ 2 ଦିନ ଅଲଗା ବେଞ୍ଚ ରହୁଛି ତ।
28.
All right, 28.
Who is appearing for discom?
28.
Who is appearing for
You have one problem.
discom? Who is appearing for?
Discom, I am appearing. 2 and 3.
Mr. Mahdi, it will come on first. He has got some problem on 28.
First.
We are in need on first.
All right. Yes.
December
Okay.
2020. All right. Yes. Next.
Item 23.
First.
Mishra Tripathi, counter not filed by opposite parties, man. Already counter affidavit, man. You want to go through it? Go through it. We can take up some other day.
I'm filing.
काउंटर फाइल कर दीजिए कोर्ट में
ना कोर्ट फाइलिंग
अच्छा एठी फाइल करंतु आपण स्कैनिंग ये आसो
बा फिर विदाउट हम
देखो मिस्टर गुरुदत्त करन एंड काउंसिल अपीयरिंग फॉर दी कोर्ट कहां पे अपीयर पहुंचेंगे
वो ये बैंक अपोजिट पार्टी नंबर 2 नहीं 3-4
जस्ट अ मिनट बैंक अपोजिट पार्टी नंबर राइट 3 and 4 opposite party number 3 and 4 submits that is filing the counter affidavit during course of the day. Stop. He has also served a copy of the counter affidavit on the land and council for the petitioner.
Yes, as well as the land council RBI,
as well as the land and council for the opposite party number 2. RBI. And the Union of India is a party. Union of India.
Union and
Yes, sir.
So give him myself copy. Filing a counter affidavit.
I'll give it.
No. Acha, ठीक है जी. He will submit that he will also serve the copy of the counter affidavit on both opposite party land council for the opposite party number.
Engage internal dispute from India.
You don't want that.
ना किसी नहीं आपनकर
अच्छे ने पक्षटा कर दी जान तो सही है. मैं कहला में काटी दो आपनकर भी जहाँ पाइबा कथा प्राप्ति होबनी तो
काटी देलो
किसी नहीं
अच्छा मिस्टर Party Land Central Deputy Solicitor General submits that unnecessarily Union of India has been arrayed as opposite party number 1 and the Land Council for the petitioner submits that he is not seeking any relief against the Union of India. Stop. And therefore, this the Union of the opposite party number 1's name stands deleted from it. Yes, next. When you want if you want to file any rejoinder on this counter, you can file it. So what date you want? 2 weeks time. 2 weeks time. So let it come on 8th of December. 15th. And counsel for the petitioner submits that 2 weeks time may be granted to file rejoinder to the counter filed by the so and so bank. Matter will be listed in the commencing from 15th December 2025. Yes.
Item 24.
Next week, madam, Mr. Senior Advocate Collins.
You are for the petitioner. What is your good name?
Sushant Kumar Raut, ma'am.
You are mentioning on behalf of Mr. Kali Prasanna Mishra, and Senior Advocate, who is appearing for the Union of India.
We are appearing.
The pleadings are complete.
1347 and the 256 appear by Prakash Bari for BSN.
No. Eti achi.
We are appearing for 1, 3, 4 and 7.
No, counter not filed will lekha isi.
Again, I am corinu see BSN.
No, but it is mentioned that with the counter at flag A will lekha isi. Seta counter ke file korchen.
BSN korte hobe.
Synopsis of the date chart at original application. Counter affidavit by opposite party number 2 of flag A lekha isi. Where is that counter? Counter before Acha. अच्छा ये जो काउंटर का सेटी फाइल है इतना जो ट्राइब्यूनल से वो अच्छी ऑलराइट Mr. Pari, you have not filed the counter affidavit.
Yes, we will not file. We will receive the instruction. We will file within 10 days.
Sure. The Mr. Pari, Land Deputy Solicitor General, who has accepted notice on behalf of opposite parties number 1, 3, 4, and 7 submits that the instruction has been sought for filing the counter affidavit and some more time is required. Mr. Prakash Barik, Achanti na na.
I will intimate.
Learned counsel for the petitioner, Mr. Sushant Kumar Rao, submits on behalf of Mr. Kali Prashanna Mishra, senior advocate, for adjournment. So, 2 सप्ताह परे आसु अपने अभी तक counter affidavit. Put of this matter commencing from 15th of December 2025. Counter affidavit be filed in the meantime. Yes.
Item 25.
I'm paying 1 week time to tell.
Who is for the petitioner?
Petition said Maranam.
Yes, Mr. Marana.
25 counter not.
Counter not filed already.
You prepare for that?
The land counsel for the petitioner is present. Land counsel for the opposite party seeks some more time to prepare and file the counter affidavit. How much time you want?
1 week.
1 week time. Let it be on 8th of December 2025. Yes.
Item 26.
The 8 December is some difficulties.
As a 15th of them. Next. 26, Mr. Mishra.
Yes. In the meantime, they have deposited 20 lakhs something. The account has been upgraded.
Which for the bank?
I am on the bank on the list.
Aja. Nobody is appealing for the petitioner.
Yes, ma'am.
So what was the order passed?
So I have passed only notice and list.
What was the prayer of this petitioner?
There for the auction, stay of the auction or auction is already gone. And in the meantime, they have already deposited 20 lakhs of rupees out of 75.
That the auction purchaser has deposited.
No, auction purchaser. No, loanee, the borrower.
Acha.
Who is the petitioner is the loanee.
Loan.
So now what happened to that?
The account has been upgraded.
So you have not issued any auction sale notice?
No, sir.
So where is your counter affidavit?
Yes, ma'am.
In that counter affidavit, you have mentioned all this.
No. After that, they have deposited.
So file an affidavit.
File that affidavit so that it will be a part of, so that we can dispose it of.
Yes.
What you are supposed to mention, just give it. Seal marne ka liye.
The entire money has been paid and
only 20 lakhs something they have.
Which paragraph you have mentioned?
After that they have deposited.
এটা হচ্ছে আপনার counter affidavit. এই যে deposit করছেন বলি কହୁଛନ୍ତି আপনার latest information.
That's what.
The you are Mr. Mishra.
Yes, madam.
Mr. Sivadatta Ramprasad Mishra and Counsel appearing for the Bank of India submits that in the meantime some development has taken place and the petitioners have deposited
20 lakhs something.
20 lakhs and some odd with the bank, and the account has been updated, and he wants to bring the same on record by way of an affidavit, and the matter may be taken up a week after. Put up this matter on such and such date. Put a week for non appears for the petitioner. Yes.
Item 27.
I am the opposite party.
Petition.
We stands to sub-item.
Counter affidavit not filed.
I have to file counter affidavit.
You have not filed, and
No, we have also. We are in the.
how many opposite parties are there?
Because I am in this second item.
No. The first one, only one opposite
In
party.
every case, there is
Only one
party. Because these are individual units.
Sure. So in none of the cases, affidavit has been counter affidavit.
I think my learned friend has filed in the second.
Second sub item. 17 November, they have filed a reply affidavit.
Okay.
That is on record. Copy has been served.
I'll file a small response to that. In other matters, affidavit has to be filed.
All right, let me file here. Item number, first leg WPC number 27445 of 2025. और tax ratio, ये जो 27706 of 25, 27710 of 25, और 27712 of 25. It a similar order. Hello, the London Council for the opposite party seeks some time to file the counter affidavit. Put up this matter on such and such date. Counter affidavit be filed in the meantime, serving copy on the London petitioner. बाकी जो WPC number 27698 of 2025 लिखिए Mr. Lalit Kumar Mahalana and counsel appearing for the petitioner submits that he has received the reply affidavit dated 17/11/2025 and he wants to file his response to this affidavit and the matter may be taken up on some other day. List this matter on such and such due date re आपको रखी थी वे with so and so, है ना? A response be filed in the meantime, serving copy on the land council for the opposite party, है ना?
Interim order,
interim order,
24/9/20.
Extended till next day. Yes.
Item 28.
Item 28, they provided bunch of documents for day for Friday to examine them.
Who has filed
No, my lord, sir directed me only to put the points of argument.
Yes.
And my points of argument, I have put it in the, and the supporting judgments I have annexed. The supporting out of the supporting
the Union of India is the party.
Yes. Where the petitioner, they have provided some documents.
No document has been provided.
You have the petitioner, let us hear it.
Yes. The document or did what this document, and I seek some time for 1 week time for next week. But my limited submission before my lord, this my learned friend submitted on that day that he was the equal footing the person who have getting benefits. They have adjourned the superintendent post. It is not correct. And this judgment we have examined the Tamil Nadu High Court, the Madras High Court, that Madras High Court judgment is supporting us. And in that, basing on that judgment, it was taken and remanded back for the tribunal for fresh adjudication. Here is the case, he has given technical resignation and he has observed, he is getting promotion. And after promotion, he has get retirement. He is saying that we are getting promotion there, we are getting benefit there. As well as the others are getting superannuation and
technical resignation has been defined.
Yes.
Defined.
That is Madras High Court.
The order
that is only for the government servant. He is not a government servant.
The order
that very word, the office memorandum dated
31/1/2025, and the prayer of the opposite party in that way was to count his service from 4/1/1988 to 15/3/2007.
Yes.
Rendered in the NIMR under the Integrated Disease Vector Control project as qualifying service for all purpose pension and other pensionary benefits.
Yes.
Okay?
Yes.
And you have passed that order for which he wants to pass the same, and it seems in the operative part of the London Tribunal has been pleased to allow the original application and has directed to treat the applicant as an entrant in the government service prior to 1/1/24 and to consider the grant of pension and pensionary benefits. Counting his period of service from 1988 to 2007 rendered in MR under the so-and-so as the qualifying service for the purpose of pension and pensionary benefits.
Exactly. And
also directed that the consequential action is to be taken and that is to be completed within a period of 60 days, right?
Yes. Yes.
So
their judgment was
senior advocate said that we will not file any counter affidavit. So that is how we have fixed this today for
a hearing. But they have given a bunch of synopsis with a
citation.
Ignore, Mr. Party, ignore that. Come to para 11 of the impugn order.
Yes, my lord.
See,
Just
the only thing which why you are not giving the benefit is he resigned on 15th and joined the next day. So there is no continuity of service. That's what you are saying.
no.
That resignation is termed as a technical resignation. That's what the para 11 deals with. Just see para 11.
Well, my lord, prior to that, I am just sure, my lord. I am just prior to that, I am just enlightening one thing. Lordship is they are referring the office memorandum of 17th August 2016. That office memorandum is confined. What is the technical resignation? The first paragraph itself. It is a office memorandum issued for the person who is on the service. Suppose he was in the regular service, he is given technical resignation, then there is no issue. We are bound to accept this. He was not in service, he is in ad hoc post, he is along with the others. Others are not been selected, he has selected. So what happened? He has given resignation. Thereafter, he is earned in the fresh post. That's why he has given promotion, all these things. Those persons have been observed.
Let us read 11 how the tribunal deals with. Para 11.
11. Tribunal observed it basing on the Supreme Delhi High Court judgment.
Delhi High Court and Madras.
Madras High Court is latest decision is what I am citing.
Let us read 11. Para 11.
Page 28. Page 20.
28. Page
Yes.
28.
In the case in hand, the counter show also in course of hearing, it has been admitted by the respondent that in compliance of the order of the Honorable High Court of the Judicature of Madras, Chennai and the High Court of Delhi, similarly situated employees engaged in the IDVC projects were regularized, that is from their initial engagement of the temporary and ad hoc basis. It is also not disputed that in pursuance to the advertisement made by the council applicant while continuing under the same respondents as a senior research assistant scientist submitted application to his employer ICMR for the post of senior research officer under the ICMR, and after being selected through a regular process of selection, he tendered his technical resignation by the application dated 15/3/2007, and thereafter in the application dated 16/3/2007, he had intimated that since he has been posted at the field unit and working as officer in charge, as such he may be treated to have joined in the post of senior research officer. From the above, it is established that the duties discharged by the applicant in IDVC project as a senior research scientist on temporary ad hoc basis was same and similar to that of the duties after his joining to the post of senior research officer. After joining, he was allowed protection of pay in the post of senior research officer under FR 22. As stated by the applicant, he has not been disputed by the respondents. The respondents have stated that since the applicant was continuing purely on temporary and ad hoc basis under the project, his plea that he is earned in the post of senior research officer after technical resignation is not acceptable as per the DUPT option under such and such 17/2016. But we find that this plea has taken by the respondents for the first time in the counter without any supporting documents to the above effect. After submission of technical resignation by letter dated 15/3/2007 and the joining report dated 16/3/2007 in the respect of the senior research officer in the post of senior research officer, the applicant was allowed to continue in the post of senior research officer by the respondents, granting him all the benefits, including the protection of his pay and financial upgradation, etc. By the order dated 12/19/2023, and thus when the applicant prayed to continue the period of count the period of service which has
the project
rendered under the IDVC project for the purpose of pension and pension benefits, denying the same on the ground that his resignation cannot be treated as a technical one is an afterthought and is not acceptable in the eye of law. Then, my lord, the paragraph 12, this citation he has given, that reference we have given DUPT 17/2016. That is, Lordship may see, that is page 163. 163. Lordship got it. Office memorandum, technical revision and alien consolidated guidelines. The undersigned is directed, I'm just reading, my lord. That is on 17th August 2016. That is issued by DUPT, and the 2.1 is the technical resignation. As per the Ministry of Finance and Office Memorandum such and such, that is 17 June 2065, the resignation of treated as a technical formality. Where a government servant has applied, as per the Ministry of Finance of such and such, 17 June 2065, the resignation is treated as a technical formality. Or the government servant, it is very important, government servant has applied through proper channel for the post of the same or some other department, and is one selection required to resign the previous post for the administrative reasons. So unless he may be this department or any other department, he should apply through that proper channel.
But what you want to say is he was working in the project.
Yes.
So therefore he is not a government employee. Hence his resignation will not be treated as a technical resignation.
Yes.
That's why.
Yes.
Okay.
Yes.
That's okay.
Yes.
Yes, simple.
Yes.
Not beyond that.
And
You have to satisfy.
Now this
Can if you are not a government employee,
Yes.
being an employee of a particular project,
Yes.
and ad hoc employment, and though you are appointed as in a selection process, following selection process and all, once you resign on 15th and join in 16th, whether that resignation could be treated as a technical. This is the only question,
Yes,
nothing
ma'am.
else.
Firstly, my lords may take note of this fact that when I submitted a technical resignation, by saying that it is a technical resignation, way back in the year 2007, that has not been objected to by the petitioners. That was accepted as technical.
So your resignation.
Yes.
Let us show.
My lords may kindly straight up. My lords may come to my written
Now
submission.
let us see the resignation. How
Yes,
you
yes,
found it.
yes, my lords. Straight away, my lords may kindly come to the first page of my written submission which I have filed.
This is part of the document.
No, my lord, the written submission which I have filed, my lords. Kindly straight away come to
Annexure 7.
Yes, paragraph number 9.
Annexure 7.
Paragraph number?
No, in the read petition, Annexure 7. Just see.
Annexure 7, my lord.
Yes.
Yes, yes.
That's the resignation.
42. Page 42. No.
42.
That is, my lords, I have categorically stated. Kindly see the heading. Technical resignation from the post of senior research scientist, IDBC project regarding. And there was a vacant post of SRO at NIMR Delhi, for which advertisement was issued by the council. I have applied for the said post, which was duly forwarded by the director NIMR, that is through proper channel. And to the director ICMR Delhi, since I have applied through proper channel, and I have been selected for the post of senior research officer at NIMR, it a council's letter number so-and-so dated 7th March 2007.
This may be treated as a technical.
This may be treated as technical. And then kindly see the next page. I join.
They have accepted it.
On the next page, in accordance with the council's letter number so-and-so, following the officer promoted scientist as a flexible complementing scheme. No, my lords. The joining letter was immediately thereafter. They have not filed it, but it was in my way. Copy of which has already been taken on record, my lords, by virtue of since they had not filed it, my lords have taken it on record, the original application which we supplied. That is there in that. So therefore, technical resignation aspect goes.
This after 15.3, the letter which they have issued to you.
Yes.
Where is that letter?
The acceptance letter.
Acceptance letter.
Acceptance. Acceptance is not issued to me. Acceptance is by them in their own office.
Yes. Where is that?
That page is 16th March 2000. That is in my way, my lords. In the way, it is there at page number 60. Would my lords like to come to my written submission?
6 series.
Yes, my lords.
That is 37 to 640.
Yes, my lords. And if my lords may kindly permit me to read only paragraph 9 of my written submission.
No,
Yes.
let us get the document. Let us understand that.
16.3
Yes.
letter is annexed 6.
This is at my lords page number 40. Joining for the post of senior research officer NIMR Delhi regarding. I have been selected. Very next day, my lords, I'm giving because in the afternoon I demitted my office from the post and joined on the next day forenoon. I have selected for the post of senior research officer NIM Delhi by the survey of so and so, bid as council's letter number so and so. I have joined my duties on 16th March 2007 forenoon at IDBC. Same. In fact, when my position changed from the temporary post to that of a regular post, same office, same table, same chair, same subordinate staff, same mitti, cement, everything same. I continued with the same post only. There cannot be a distinction.
Once accepted is resignation. Yes, Mr. Bani, once you accept it,
we are not disputing about the acceptance of his joining.
Then,
but we are disputing.
No, that is the reason the tribunal says that it is an afterthought.
No, it
Paragraph 11 says afterthought because you have accepted it to be a technical resignation.
My lord, now it is a prerogative to Lordship to decide. It is cannot be afterthought because I am substituting my lord. Lordship says the same page I am referring. Annexure 6 running. I have been selected to the post of senior research officer at NIMR Delhi on the pay of scale such and such by council's letter number such and such dated 17th March 2007. I have joined 17th March 2007. The 7th March 2007 is the letter where he is given appointment. And I have joined my duties on 16th March 2007 for noon at such and such Ranchi. I am already posted at the field unit and acting as a OIC as such. My joining may be treated as a deemed to have been joined at New Delhi. He has submitted this application to the authority. No such communication made in this regard because he is appointed purely on.
Why have you not rejected it?
My lord, we have
accepted
not,
it and you can,
because
see, there is
this,
a concept, there is a principle of legitimate expectation.
Yes.
Once you accept this, the legitimately he is expect that
we are not accepting his previous service. We are accepting his new joining, my lord. Next page, let's see page NHR 7. There was a vacant post of SRO in such and such in New Delhi for which the advertisement was made by the council. I have applied for the said post, which is duly forwarded by the director of such and Delhi to the director of general such and Delhi. Since I have applied through a proper channel, this proper channel means the application for their advertisement, not that technical arrangement processed on the proper channel. It is misrepresentation. He has to submit the technical explanation with a proper channel. Who can do this? A permanent employee can do this.
Proper channel means appointment is in the proper channel, not.
Let me see.
His subsequent appointment is through proper channel. That's what.
My lord, here is the case. Once again, I am defined also. The present tribunal has passed an order basing on the Delhi High Court.
Joining that post of senior research officer,
yes,
he has also been given promotion.
He has given promotion.
When he was given?
He has given three promotions in his service career.
This one. When
after this one, he has got promotion.
16/3/2007. The first promotion was made to the post of
2013-16.
What is that promotion?
19 8 series. It is a 9/6/2013.
Annexure 8 series. Just a minute. So से जो जॉइंट हला डेटेड हला 16/3/2007 ठीक तो तांकर फर्स्ट प्रमोशन आसिला come to that
yes page 43 start
12/6/2013 that is the first promotion after he joined. So you just come to that
scientist D. Yes, I guess promotion of the scientist under the FCS as per the health research scientist cadre of the ICO 2007 as amended 2012. Scientist C to scientist D. Then memorandum. In, sorry, in accordance with the council's letter number such and such dated 7th June 2013, copy enclosed. The following officers have been promoted for the scientist C to scientist D under the flexible complementing scheme of the Health Research Science Cadre of ICMR 2007 and as amended 2012 in the pay of scale such and such plus other usual allowances were admissible
So how
under
many
the
years
such and
after
such.
somebody suppose remains as scientist C, how many years thereafter he can be promoted to scientist D?
Scientist C to scientist D.
Yes.
The concerned officer tell me the 5 years. I didn't have that.
On the year phone, we want that there must be something that after minimum
Yes,
this
yes,
year.
yes. Yes, I got my point, let's just. 5 years.
5 years. But
No,
come,
5 years. Sorry, 5 years.
come to page 45. What was your stand? Now in the counter you take a different stand. Come to page 45.
Memorandum.
Please read it.
Yes.
Please read it. Have you said that it is not technical resignation and all?
With reference to the representation dated 16/12/2018 for continuing IDVC, counting IDVC project, service of the pensionary benefits after Manoj Kumar Das, scientist E, is hereby informed that the matter was taken up with the council, which behind their letter that number such and such dated 13/2019 has reiterated their earlier stand stated by letter number such and such dated 11/10/2018 that there is defined procedure for counting the post service rendered on the contract basis under the CCS pension rules. The project employees are not considered as a government employee, and as such there is no provision in the fundamental rules for the pensionary benefits without regulation of service from the date of initial appointment. Copies of the ICMR letter such and such.
Wherever you say that technical resignation and all, nothing is said. And this is the issue whether the temporary employee, those who are not government employee, their service will be counted for the pension purpose or not. This is the issue decided by the Bombay, Jharkhand High Court, Delhi High Court, and Madras High Court. And here also you are not saying that you are not entitled because you have resigned.
Yes, we are saying so, my lord.
Where have you said?
My lord, we have specifically stated that because his temporary service was not counting as a regular employee.
Why he not counted? You are saying that
because of the official own issue with the government.
No. The fundamental rule is not available. That's what your case is. And this precise point was decided by the Delhi High Court. Saying that the government employee, the ad hoc employee, their services will be counted. That's what is the precise point. There also you have not taken the point that you are taking.
The office memorandum issued on 2014 is very much clarify about the technical realization. So by which
First of all, where have you taken the point? First in the counter or somewhere else?
It was taken by the tribunal itself, and we are
no, on your
pleading.
When you rejected their
there is no question of rejection because he is not coming entitled to this report. He has given technicalization. Whoever appointed as a fresh appointment, we are not considering him as a employee under the technical temporary basis. Again, he was regularized as a regular basis. We have not considered this. My lord.
Line page 45 project employees are not considered as government employees. Since there is no such provision. This is you are telling for the first time.
No. That issue, my lord, that reference I am just entitled to the 2014 the circular 163 page Mercy. Once again 163 annex R by IV. Page 163, my lord. I'm reading, my lord.
Project employees are not
The first line like technical legislation such and such. The undersigned is directed to refer the Department of Environment for the even number dated 26 December 2013 on the above subject to say that the guidelines instructions regarding the technical legislation have been issued from the time to time. It is now proposed to further consolidate these instructions as the department continues to be received frequent references on this issue. The technicalization they have as per the ministry finance official notice such and such dated 17 June 2065. The 65 you will see the resignation is related as a technical formality where the government servant has applied through proper channel. Yes.
Same thing, the scientist promotion, ସେଇଥିରେ ପୁଣି ସେମାନେ ସେଇ same court ରେ return ହେଇଛନ୍ତି, creator court ଦେଇକି ଏଠି promotion ଦିଆଯାଇଛି। Subsequently,
Yes. Yes.
That has not been challenged.
But recently we have given the judgment page 264 Larsimesi, Annexure 14. This letter decision of the Madras High Court. Yes, my lord. That is P. Philip Samuel. The same self issue. The tribunal has 264 page start and the 268. Sorry, man. 268. Read application.
Annexure 14.
In that case, even though the other High Court is not binding on this court, but it is a reference to our side because basing on that cat has passed the order and cat. So that is 2 Larsimesi. Para 2 page para 2 page 270 para 2. It starts from my lord 268. Yes. Paragraph 2, my lord. It is first. Yes. Then paragraph 7. Yes.
It is admitted that
Yes. It is admitted the fact that the applicant was appointed in the year 1988 on contractual basis for the project, and thereafter he was appointed on direct recruitment as a scientist on 19/7/2013. The petitioner himself admitted that he was appointed a contractual basis as the project till as a basis as in the project till 18/7/2013. Initially, the salary was on consolidated basis, and thereafter it was transferred to pay scale. Though it is a transfer to pay scale, the temporary service on the contractual basis cannot be taken into account for the counting the period for pensionary benefit. It was well settled law that the temporary or contractual basis cannot be counted for pensionary benefits, and the date of appointment as permanent employee has to be taken into account. In this case, the petitioner himself admitted the employment of contractual basis, and again the year 2033 he was appointed the scientist B through direct recruitment and thereby he accepted the contractual basis and he was not challenged the same initially immediately after his regular appointment. Further, the appointment was not appointed on observation, and he was appointed on the direct recruitment. Therefore, the past service rendered by the petitioner on contractual basis cannot be taken into account for the pensioner benefit. The Land Central Tribunal also elaborately discussed about the same and dismissed the application by holding that the petitioner is not entitled to account the past service rendered by him for pensionary purpose. Further, the petitioner was appointed after 1/10/2004 and thereby the old pension scheme was not be applicable to the petitioner's case. As discussed, then any
Yes. Order thereafter whether this P. Philip Samuel has approached the Honorable Supreme Court.
I didn't examine, sorry.
Project to
Maybe he was in the project, but there was a scheme operating. 2004 scheme was
P.
operating.
Samuel Mathur was
There, what had happened is there was a scheme operating in 2004.
This is your scheme.
No.
Whoever working in whatever capacity, it is under scheme and a particular period and particular basis.
Was working in a local project in South Arcot district. That local project was a temporary project which was closed down in 2013. Thereafter, he came to the regular by appointing and he could not show. But I have dealt this particular aspect in para number 16 of my written submission. If I see page 8 of my written submission, I have comprehensively dealt with this aspect.
In that part, I am also clarifying in page 32, annex 2, first appointment. The first paragraph is the applicant is a purely temporary and ad hoc basis and is could terminable with the scheme project or the long as required. So whatever scheme is coming by the government of India, that should be implemented through ICMR, engaging the technical persons, whatever capacity may be. And it is purely on contractual basis. Suppose scheme close, their service will close. But taking advantage of their service of the scheme, they will claim for pension, which cannot acceptable based on the DPT circular. Those persons, it is also admitted, those persons who are working with him, they have been regularized based on the Supreme judgment. But superintendent post has been created. All the benefits are given the same post. You are not given promotion. He is the person given promotion because he has joined in the fresh post. His technical scheme, whatever period of them working in the scheme, cannot be mixed with the regular service of period. This is our humble submission because DPT circular.
Yes, Manoj, first kindly, as far as P. Samuel's case is concerned, kindly have a look at page 16 of my written submission, page 8.
Para?
Para number 16, Manoj, page 8 of my written submission. Under the heading, a new ground raised by the petitioner in the WP. The petitioner in the instant WP has raised a new ground to the effect that a CAT Chennai bench in a similar matter in way number so and so, P. Philip Samuel versus Director Vector Central Research Center has rejected a similar contention as that of the opposite party. And the said judgment has been upheld by the High Court of Judicature at Madras in WP number so and so. The said judgment is distinguishable on facts as follows. The project in the case of P. Philip Samuel was a local project in South Arcot district. Para number 3 of the High Court judgment at page number, this page is wrongly given as 261, it will be 272. It is a typographical error. The said project was closed. Which factor was taken into consideration for dismissal of OA and WP? Para number 32 of the High Court judgment, this is valid again, the page number is wrong, it is page number 273. Both the learned tribunal as well as the High Court were not shown any rule to support the claim of P. Philip Samuel to count the entire period of service for pension and pensionary benefits. I am showing it in this particular case. And D, neither the learned tribunal and the High Court were shown the relevant laws on the subject, nor the same was examined. Judgment of the subject are Mahesh Chandra Burma versus State of Jharkhand, Supreme Court, Prem Singh versus State of UP, Harbans Lal versus State of Punjab. These are the judgments, my lords, 10 judgments which the tribunal has relied upon for granting me relief has not even been considered and shown there. And in view of this, kindly come to my last paragraph, E. It is an established law that when a judgment is given in ignorance of a previous binding judgment or a statute, then the said judgment is for inquiry and is not to be followed in subsequent cases. And I have given, my lords, A.R. Antule versus R.S. Naik. That is settled principle. Now, my lords, today kindly come to these 3 paragraphs which I have pointed out in my distinguishing facts. That was a local project working in the South Arcot district of Madras, and that project was closed down. These are the factors which has been taken into consideration by the learned tribunal as well as the High Court for dismissing their claim. In my case, the project is continuing since the day I joining. Even today it is continuing. After my retirement also, the project is still continuing.
The same in ICMR.
IDBC project is still continuing. It is not a temporary project. It might have started as a temporary project in the year 1970 or something. When I joined in the year 1988, till today, without any break, this project is continuing. And secondly, whenever a person is appointed, the IDBC project doesn't have any independent existence. It has got an existence only under NIMR. It is not that IDBC has got separate rules and the NIMR is under IDBC and they are operating that project. No, it is the NIMR under whose rules the IDBC project is operating. The IDBC project has no separate independent existence. Whenever a person is appointed in the IDBC project, the selection, appointment, everything was done by ICMR. And secondly, when a person is appointed, he was given the pay scale not of any IDBC project. He was given the pay scale of central government employees. All these things I have elaborated in my written submission. And whenever a person is appointed in the IDBC project, he is governed by FRSR, he is governed by CCS leave rules, he is governed by CCS CCA rules, he is governed by CCS pay fixation rules. The benefit of the pay, central pay commission, third pay commission, fourth pay commission, fifth pay commission, all the benefits which are given to the central government employee have also been given to the persons who have been appointed in the IDBC project. All these things were in paragraph number 9 of my written submission. I have elaborated this. Kindly have a look at that paragraph for a second, only, my lords.
My humble submission.
1 second, let me complete my.
What I am submitting, if they are elaborately filing a written or submission, I didn't have a scope to give the reply. Because either they file the counter or I will give the reply on the written note submission. There is scope to give the reply in this regard. So let them file the written note submission. Basing on that, I have a scope to file a reply.
This is the written note of submission.
That's against which again I will file an objection to the written submission. Let them by way of pleading they should come forward.
Of submission objection from the
say whatever they are submitting, my lord. What is my scope to give a reply in this regard?
No, you have got it last week, you said.
Yes, last week I have received. That's why I am asking time to give a reply in this regard. Because generally on the pleadings, either they have filed a way of affidavit, will give the reply to the same.
You see, the learned senior advocate said, and we have also recorded in our order.
Yes, they are not ready to file in counter. But the way he has filed into submission is required to give the reply because some technical issue they are pointing is required to give supply. This as regard to project, as regard scheme, what they have technical issue they have raised. We have to
see these things were not part of the pleading before the tribunal. We can't expand it everything here in the.
My lord, some things are there. Whatever. Many things are there is required already been taken in the tribunal. On is required to be enlightened again because they are what issue they are coming before this court. We don't have a scope to file reply in this regard because they have filed a written note of submission. Now they are coming in new things which required to be enlightened.
What is your job profile, by the way?
Same job which the regular staff.
No, what is that?
See, this is a vector
malaria vector.
And the research etc. works are conducted by us only. We are the senior research officers. And
for example, I am saying in Raulkela there is a project. Now it is established.
It is an isolated case. It appears to me. Only isolated one case.
It is impact in all over India because
what over India?
Yes, my lord. those who have regularly employed in the scheme,
That
I am one point, I am agree with the
already
land
settled by
land
different
yes.
High Court.
No. But
Only the
Madras,
issue is whether technical.
the same Madras High Court is contending himself. Now Madras High Court say those persons are engaged in the temporary contractual basis.
If you would not have resigned, you would have regularized him.
No.
Yes.
We are aware about the same post, but for the same post, not in the post of this post is promotional post.
Same post.
You will not able to get any promotion.
Same post, but past service you would have calculated.
Yes.
But for his
No.
resignation for one day, you are not doing it.
There is some confusion, my lord. Those persons working with you, we are bound to regularize because of the direction of the court. But they are retired in the same post only. They are not getting any promotion.
But you have given that.
Superintendent post, and that post was abolished again. Because the superintendent post has been created, they have been observed, they have given all benefits. Thereafter, that post was abolished. They are not giving promotion, they are not giving, he is getting promotion, he is getting the much higher benefits, all the higher scale benefits as per his service period.
Yes. Yes.
They were promoted.
No.
My lord say, my lord and friend is giving a wrong statement.
No.
They have also been promoted. And their entire service has been counted for the purposes, and it is clearly mentioned.
Then these things have to be clarified.
And but these things
you are trying to say the people those who have been regularized, their past service is given.
Yes.
They retire in the same post after
Same post and the post was abolished.
He after resignation and joined in the same post got promotion.
Yes.
So he can't be doubly benefited. That's what you are.
Double benefit. Yes. Exactly, my lord.
Those persons who were regularized and who had got sufficient length of service after that, who were eligible for promotion subsequently, they have been given promotion. My learned friend is referring to the Raurkela case. Raurkela case I had only dealt with. Mr. What was the name of the first? Thageshwar Pradhan was the applicant in that particular case. He got a promotion. He was the person who was regularized and he got promotion thereafter.
So, Mr. Farhi,
yes,
he is.
If you want to make some submission on the document, working documents, you say he has filed, even you have not gone through, but mostly these are all judgments. So we can keep it next week if you say we can.
Further argument.
Yes. We will show that argument has started.
Yes.
And it is will be taken off next week. Whatever instruction. But this is basically as we find.
But senior seats they have added
some
I have
other
to
dated
contact something. I will give in reply.
But rest are the judgments.
Yes.
All the
But you cannot compel him to file the counter affidavit.
No, we are not needed. What they have given, then I have to give a substantial reply by way of written note of submission or what.
Even those cases where people have been directly appointed after being on the temporary service, Supreme Court says that you cannot ignore such big length of service, even though it has been rendered in temporary capacity.
That's the entire idea.
Mahesh Chandra Verma, Prem Singh, these are all judgments merits on which
there is no quarrel. The quarrel is you resign and join. That's the quarrel.
My lord,
whether that will be
even in
treated as a continuity of service or not.
My lord, the Honorable Supreme Court goes to the extent of saying that
Can you give a single case?
Yes.
Wherein such type of case, this type of resignation has been given, and then this issue has come up and it has been decided in favor of the petition.
Just see if you can.
Technical resignation. No. I am only submitting that. Suppose let us take for a minute that this is a technical resignation. He has submitted a technical resignation.
No, you can find out it is not that in India this case has happened for the first time. We just want that since we are adjourning it to next week, you can just see that way.
All right, I'll since it has fallen from my lords, I will
say heading of technical resignation.
Yes,
maybe that if you search for like Manupatra, etc.
Yes.
Get the decision.
I'll do that.
So we'll take up next week and you take instruction. So please tell us when we'll keep it.
And you have to answer. Having accepted the technical resignation, can you turn around and say that
those persons have been engaged. They are not giving promotion and they are observing the same level and they have retired. That part I am
Yes. The Mr. P.K. Pathi, and Deputy Solicitor General for the Union of India, Mr. Abhay Kumar Paidal, and Senior Advocate on the Associate Manager. Mr. Padi had submitted that he has received a synopsis of submission from the land senior advocate appearing for the opposite party, which runs almost to 341 pages, and it was received by him last week, and he has not gone through the entirety, and the matter may be taken up next week. As prayed for and on the consensus of both the parties, place this matter on
12th December ballots में put it. 12th December आज पाठार ballots में put.
all Higurani, set of the Hiran, keep a date tap on
12th December.
12th December 2020. Yes, and if you want to file anything, please.
We'll file, and then serve the copy also.
So that,
yes.
On that ground, yes.
Definitely.
And the written submission is now counter in disguise.
My lords, may kindly read my written submission, paragraph number 9, that has explained this entire thing very exhaustively.
All right, next.
Item 29.
This is case file.
Neither AD nor answered notice on return on opposite party number 1 to 5. Somebody has entered appearance.
LIC Housing Finance.
No, opposite 1 to 5.
Subhasis Patnaik, I think, my lord.
He has entered appearance for all the opposite parties.
No, sir, I am appearing for opposite number 5, your lordship.
I am appearing for 2 to 5, 2 to 4, 2, 3, 4.
2, 3, 4.
2, 3, 4.
And you are for OP 5.
Yes, sir.
So, what about OP number 1, the LIC Housing Finance Limited?
Mr. Subhasis Patnaik appeared, but his name reflected in the cause list.
He is appearing for P1.
LIC Housing Finance.
Let us see that. Wakalat number of article. Subhasis Patnaik आप में appear करते. Actor Subhas Kumar Patnaik. Subhasis Patnaik देखते.
Subhasis.
Mr. Patnaik is not there, so just Mr. Mishra, you have not received any counter affidavit.
Counter filed by opposite party number 234. 234. Borough card mortgage.
That has not been tagged, madam.
अच्छा की फाइल पर जाएंगे
234
234 काउंटर एफिडेविट फाइल है अच्छा व्हाट अबाउट फाइल करना थी you don't intend to file out
So sir, we are supplying.
अच्छा when you file that counter affidavit
filed my lord last week I have
last week you have received a copy of that
my lord I have received.
So are you sure that Mr. Patnaik is appearing for P1?
His local firm
name has been reflected.
Name has been reflected. We do not know for whom he is appearing. So he is not there. That's why we are asking you. So let that counter be placed on record, and we'll take up this matter next week. Though it is mentioned in the registry has pointed out that the AD or the unsub notice has returned from opposite party number 1 to 5, but it appears that Mr. Prashant Kumar Satpathy and his associates have entered appearance for opposite parties number 2 to 4, and who is appearing for OP number?
So Lakshman Soren.
Where is your Okalatnama? ধরিকিন বসছেন না কোন?
So it is a copy of we have already filed on 14th.
And Mr. It is stated that Mr. Lakshman Soren
Yes, my lord.
has made appearance for opposite party number 5 by filing wakalatnama on kebe file
14th 11.
14/11 14/11/25. It is further stated by the Land Council appearing for the opposite parties number 2, 3, and 4 that the counter affidavit has been filed on the last week
No, my lord, that 17/11.
on 17/11/2025. And copy has been submitted by the Land Council for the petitioner. Let the counter affidavit filed by the opposite party number 2, 3, and 4 be placed on record. The wakalatnama filed by Mr. Soren
Yes, my lord, sir.
for the opposite party number 5 we also placed on record, and the name of the Land Council for the opposite parties number 2, 3, and 4. So also the Land Council for the opposite party number 5 be reflected in the cause list henceforth. It is stated by the Land Council for the petitioner that Shubhasis Patnaik is appearing for opposite party number 1.
That is reflected in the constitution.
कहाँ पे हमें तो जानना आपको क्वेश्चन ऑप्शन नंबर 1 पे तो अच्छा. So the name of Mr. Subhasis Patnaik is appearing in the cause list. तांगा ना केम तले possible वकालत नामा तो एटी नाई. But it is not clear for whom Mr. Patnaik has entered appearance. The official clearly point out, and if Mr. Patnaik has filed any wakalatnama, the same shall also be placed on record. You don't intend to file any rejoinder, so that make a statement whether you, after going through that counter affidavit, you intend to file any rejoinder, or we'll just take up the matter for hearing.
My lord, I will file.
You want to file? How much time you want?
1 week time.
1 week time. Mr. Mishra and counsel appearing for the petitioner bank submits that he intends to file a rejoinder affidavit to the counter filed by the opposite parties number 2, 3, and 4. And for such purpose, he requires 1 week time. List this matter with a saptaha par. Okay. Yes, next.
Item 30.
But he, Mr. Rotho and Mr. Kor. Yes.
My lord, I may be permitted to submit on behalf of Mr. Rotho, my lord.
Yeah.
The counter has not seen.
Mr. Kor, counter affidavit ready. Give him a copy so that Mr. Gurudatta Karol and counsel appearing for the Bank of India. Have you filed it in the, or you will file it?
I will file it.
Achha. Submit that during course of the day, you will file the counter affidavit. Stop. However, he has handed over the copy of the counter affidavit to the Land Council for the petitioner to seek some time to go through the same and file rejoinder if any. And for such purpose, he wants some other stuff. Upon the payment,
Hard December.
Acha, 1 week time for them to list this matter on 3rd December 2025. The counter, if it is filed by the Land Council for the opposite party, shall be placed on record. Yes, next.
I'll file it in the.
You file it. Okay. Password code for it.
19th, madam.
Wait. First item was 7.
Pass over item number 7.
By item number 7, madam. On behalf of Mr. Padit, he is on his legs, madam. So my Monday, madam.
Mention is made on behalf of Mr.
Subir Padit, madam. Senior advocate.
Subir Padit, senior advocate, who is supposed to argue the matter on behalf of the petitioner for adjournment. List this matter on next Thursday, Wednesday. It will come on 26th November. All right. 26th November 2025. Yes, next.
Item 9.
9.
We are for the opposite party, sir.
Ajadi land, Mr. Party land, Kauna Kana and the Kao,
SS Kassim.
Mr. S.S. Kashyap land, Senior Panel Council is present for the Union of India. The name of the land council be reflected in the cause list.
All the opposite party.
For all the opposite party. Tapare item number 9.
On behalf of Mr. B.B. Simon.
Yeah.
Let prefer one minute after.
Acha. What is your good name?
Satyajit Paltasi.
Not again. Wants to appearing for Mr. Swine 6 for an adjournment. Kebe chahuchandi?
Prefer 1 week after the.
For 1 week adjournment. Is this matter on such answer?
Item 19.
What is the matter relating to the compulsory retirement of the petitioner who challenged before the London Tribunal of Central Administrative Tribunal. The order dated 5/4/2016 has been quashed and London Cat directed. Matter kindly have a glance, page 25.
They have filed the counter, they have filed the rejoinder. So give it some other day, I'm not ready.
Acha. The Mr. Pariland, Deputy Solicitor General, submits that the pleadings are complete.
Pleading complete.
Pleadings are complete and the matter may be taken up some other day for hearing. This matter kebe kahiba phone to?
Next week.
Next week.
Monday.
Monday so havani, but it will come on Wednesday.
Wednesday marriage party. Then
date.
The January first week.
No, January.
अब आप टाइप कहीं
अब नहीं तो संभव है
उसको भी नहीं आड़ हो नॉन फिफ्थ हो
December 17
पूरा सब बाहागर पूरा परिपूर्ण
नहीं 7 नहीं 17 ना 10
क्या मु कहूछु थर्ड फोर्थ राई सारंग कोट हां डिसेंबर
10 बेडरिडन है जे मारे आएगा किसी बड़े
ना मोर ऑब्जेक्शन सॉरी
हमारे ओब्लाइज
ये लीज अपडेट बनेगा नहीं
डेट चार्ट कर दियो 3 नोट भी कर
ओब्लाइज
But pardon to mention, my lord, serial number 490 of 23. I filed IA for bail, my lord. For custody.
I don't make a mention, your lordship. Lordship, 44 number item for your lordship, today's list, your lordship. We have prayed for an interim bail on the ground of wife's illness, your lordship. State may take instruction on that.
This is coming for the first time.
Yes, your lordship.
Or earlier instruction was sought.
No. It was for the first.
Which item?
44.
Item 44.
Which is that IA?
IA number 3128 at Klagi.
IA number 3128 of 2025 is an application for interim bail filed by appellant number 5, Babulu alias Babulu Muni, for on the ground of his ailment of his wife. Medical documents have been annexed to the interim application. The land council for the state shall obtain instruction on the interim application. Matter will be listed on the commencement from 1st of December 2020.
The test is scheduled for 25/11.
Yeah.
The wife test is scheduled for 25/11.
Yes, next.
Criminal appeal number 1198 of 2021. IA is pending for bail, my lord. It was an IA is pending for bail, my lord. It was
Item 26. Final application embeds the device of the appellant's mother.
Instruction has been sought for.
Okay. First it was listed because of 26.
Yes, 20.
So item 26.
Acha.
IA number
10
3166. IA number 3166.
Well,
Have you give a copy of the IA number 3166 of 2020? This is an application for interim bail on the ground of Swansea. The land council for the state has been served with a copy of the interim application to take some time to obtain instruction. Put up this matter day after tomorrow.
no, okay.
May କେବେ ଡେଥ୍ ହେଲା?
ମୋର ହେଲାଣି 13 ତାରିଖରୁ ଶନିବାର ହଉଛି 10ଟା May I pray your lordship may direct the learned district judge to verify and pass necessary order if it is true.
Subject to verification, release for
whatever has been third release. In support of the governments taken regarding the death, the certificate issued by the Sarpanch of Victoria got Gram Panchayat, that is 16/11/2025 has been annexed. The certificate copies of the land council for the state submits that he has not obtained instruction regarding the governments taken. Considering the submission made by the land council for the respective parties and governments taken in the interim application and supporting documents, and next there too, we are inclined to grant the interim bail for a period of 2 weeks from the date of release, subject to verification by the who is the trial court?
Additional
by the London trial court regarding the date of the Swanson to inspector in charge of
PS Junagadh.
এটা কাହାର ଆପଣ ଦେଇଛନ୍ତି who appellant ର?
ଦି ଜଣ 1 and 2 man. He is the mother man. She was died.
He has been released earlier. He has died.
Right.
These two are the this has been filed by appellant's number 1 and 2, namely Pita alias Kutamba, Pitavas Dandasana, and so on. So he submit that the mother of the petitioners, namely Kunchita Deva alias Dandasana, who was the appellant number 3 in this criminal appeal and has been granted bail by this court. I had order dated. Who order is AG? Acha, by order dated
23/11/2020.
No, it is 23/7/2020. As that. Verify for the IACOG city Swansma, Junagadh. Okay. Matter be placed after Swanso. Here, by the surrender certificate of appellants number 100. Yes. Where is that here? Yes, I don't certify for.
But web copy may be
Web
copy may be treated as certificate.
No, you get the certified copy today.
Right.
Okay. You are granting. Appeal number 26. 26. Then here is sole appellant lady. Just a minute. Purpur कितना number item देखना?
No payment. Can it be 3 weeks? 2 weeks. 2 weeks के लौट से होगा. 3 weeks में
10 days कर दिया. 44 तो 3 1 so plan number 5. Yes sir. Next. Sole appellant lady mala. अब ये 20. Yes next. Sole appellant lady. अब ये 25. Yes next.
Item 9, my lord. Item 9, my lord. Appellant sent an prisoner petitioner, my lord. Prisoner petition. So my name may be deleted in this case. The youngest another son will also appear in this case.
Wait, we are going serial, yes.
Supplementary
Pardon, my lord.
second up.
Item 46, my lord, for interim bail.
Item number 1, yes.
Item 1.
No, please, your lordship. Your lordship, London additional district and session judge Jasper have convicted the appellants under section 302 and 34 of IPC and sentenced to undergo imprisonment for life.
The trial court report. Answer shall be considered after receipt of the trial court report. Deposition copy of annexed.
Yes, your lordship.
Okay. Next.
Item 2.
May I please your lordship, my lord, and BC your lordship. My lord, on behalf of Mr. Amulya Ratna Panda, my lord, present appellant is convicted for imprisonment of life and pay for rupees 2 lakhs for commission of office, my lord, 6 of POSCO Act, that is in space 74 and annexure 1.
Call for the trial court report notice to be issued. You will file the extra copy and that will be sent to the IAC. The deposition copy is supplied. Yes, next.
Oblige your lordship.
147 to 65 1 62 2K and VNS and POSCO Act. 6 of the POSCO Act.
Same order. Next.
Item 4.
Yes, Mr. Behra. There are defects pointed out. Non-obvious citizen defects pointed out which will be removed 2 weeks from defect action. Oh, limitation achieve 1027 days. Ki achandi?
3 term. 4
Life imprisonment. 302 case.
302
Non-appears for the petitioner, 2 weeks time granted for removal of the defect. The instruction shall be taken by the London Council for the State through Jail Superintendent, Circle Jail Baripada, as to whether any jail criminal appeal has been filed by the appellant against the impugned judgment and order of conviction under section 302 IPC dated 31/5/2022 passed by the London Additional Session Judge Rairangpur Mayurbhanj in Sessions Trial number 77 of 2020. Free copy of the order be handed over to the Land Council for this. जेल क्रिमिनल अपील गुड़ाक से कौन करते रेगुलर विजिट करती डीएलएस सेक्रेटरी भी जाती डिस्ट्रिक्ट सबू केस रे कहुई जे सबू केस रे जेल क्रिमिनल अपील फाइल करियो जदी से माने रेगुलर ता छड़ा सी जजमेंट दे दियंती बेले बेले पैसा पत्र न देला वकिल मैंने पकई रखी दियंती ये तो डिले रे फाइल एटा तेणु हुए तो जेल क्रिमिनल अपील फाइल कौन देखीदेवे है ना हाँ 302 केस माने फाइल so you give us the report huh we are bringing it to this matter on 1st December 2025 yes
Item 5.
My lord, convict was filed on prison fiction, my lord. That's prison fiction, my name kindly be deleted and government advertisement kindly be engaged to conduct this case.
You got the vocal
Well, I got it.
yeah
My name government advertisement may kindly be engaged to conduct this case.
not
my lord.
government advocate that
Yes.
means he wants to say that
Yes.
a legal aid counsel
Yes, yes.
so you have been engaged by the legal aid
My lord, during jail visit, now I am acting as a
oh
legal LADC. So,
acha if somebody wants मोर माँ किंतु तांकर जोगाजोग करिवा द्वारा से कोन से जेना वकील काम करती उचित अच्छा ठीक अछि हां और कोन करिबो अच्छे पैनल बिल करिबो पैनल देखिए पूरा ये तो हां रिपीट पूछ जाएंगे अच्छा
ये सिंसियर
हाँ जोटा रिपीट है नहीं जो देखी से तो आरंभ करी देखिन फोन कॉल कर दिन तब पे करी हला लेता हूँ you have taken the paper book
yes, sir.
अच्छा paid you the prisoner's petition dated so and so on in which it is mentioned that since the London Council who was engaged to argue the jail criminal appeal has now been appointed as कौन से अपन पूछेंगे
LADC, Legal Aid Defense
अच्छा
Council.
legal aid defense counsel some other counsel from the legal aid panel may be engaged to conduct the case
obtain the V number.
The London Council for the state has also obtained the V number. So and so is engaged as the counsel, and the Wakalat Nama, the registry shall intimate the London Council to fill up the Wakalat Nama and file this. Yes.
Item 6.
Keep it as paper. The Mrs. Mahanti has returned the paper book which was received by her. Yes, and the same is taken on record. Yes, next.
Item 6.
On behalf of RK Patna, I pray for the next week, my lord. Next week.
next week
27 or 28.
What is the period of detention?
Senior is suffering from throat infection.
Custody certificate is there at flag Y.
Yes, my lord. Flag Y, my lord. Total
It
custody
is
period, my
12
lord.
years.
12 years, 11 months and 4 days.
Whether your bail application was earlier rejected,
No.
then why are you not filing the bail application? ताको भी कहियाउ पड़ियो अपन जो क्लाइंट पई अपन को एंगेज कराई छी से 12 वर्ष रु ऊपर रहिलानी हां तेणु बेल एप्लिकेशन एपर्यंत फाइल हेनी तेणु अपन फाइल करंतु बेल एप्लिकेशन
you are appearing for whom you are appearing for whom
आइटम नंबर 6 रे अपन तो
का पई
रमणीकांत पटनायक so
last time also adjournment is taken that he is not well
Suffering from throat infection.
suffering from
Throat infection.
throat infection
Next week, man.
file the bail application
Yes.
the Nata and the also appearing for you are appearing for Ramanikant Patnaik.
Yes, ma'am.
Ramanikant Patnaik 6 for an adjournment till next week. Put up this matter. We are fixing this matter on 26th of November.
27.
Huh?
27 or 20.
28 actually. 28. 28, 11, 29. Yes, next.
Item 7.
Mr. Chennai Jil, I may be permitted to make submissions on his behalf. Mr. Jannah was been engaged, is ill and he has requested me to make the submission.
No, you cannot place the bail matter. Let him come. It's a jail criminal appeal.
Yes,
that
sir.
he has engaged us. We'll take up next week.
All
Let's
right.
wait for so and so makes a submission, makes a appearing for so and so, 6 for an adjournment till next week. Put up this matter on such and such a case. Next week the revision. It will be 26, 11, 2025. Yes, next.
Item 8. My lord, for bail, I number 331/2025. Offense committed 498 303B 201 34 of IPC. My lord, free accusation.
I appeal. The custody certificate, jail conduct, and health condition of the application.
Who are these three appellants?
Nanda Malik, Srimati Saudamini Malik, Prakash Malik.
Who are they? What is the offense here?
Offense 498.
So when we are asking you that who are they, you are to submit that 498
B
4B
201
so
34
how
of
they are
IPC.
related.
Section 4 DBR.
Who are they? Petition number 1 is
He accused.
husband,
No.
mother-in-law. Who?
Mother, no. 3 person. 3 accused person.
ଆପଣ ଓଡିଆ ବୁଝି ପାରୁଛନ୍ତି? ତିନି ଜଣ ଆପେଲାଣ୍ଟ ଡିସିଷ୍ଟ ସହିତ ତାଙ୍କ ରିଲେସନ କଣ?
ଆଉ ବୋହୁ ତାଙ୍କର ମାନେ ପ୍ରକାଶ ମଲ୍ଲିକର ୱାଇଫ ଆଉ ନଣ୍ଡା ମଲ୍ଲିକ ଆଣ୍ଡ ସୌଦାମଣି ମଲ୍ଲିକ ତାର ଶାଶୁ।
ଦି ଜଣ ଯାକ ଶାଶୁ?
ନାଇଁ ଶ୍ୱଶୁର ଶାଶୁ
ସେ କଥା କହୁନାହାନ୍ତି।
ଫାଦର ଆଣ୍ଡ ମଦର।
So how the death has taken place? What is the cause of death?
Cause of death, kerosene suicidal death.
Who is the doctor?
Doctor 14.
PW?
PW 14.
14 minutes. Just finish.
And there is body here.
How many years after marriage the death took place?
2-3 months. 2-3 ମାସ।
Yes. Who is the family members of the deceased? Who has been examined in this case? ତାର ଘରର ଲୋକ କିଏ ଏକ୍ସାମିନ ହେଇଛନ୍ତି? ତା ବାପା ମା ଭାଇ ଭଉଣୀ?
PW 12 is the father of the deceased. And PW 10 is the informant brother of the deceased.
PW 12.
12 and 10.
12 वाला father. PW 10.
10 man.
10, 12.
ये किए?
Brother of the deceased.
Who is the informant?
Informant, my lord, we don't tell.
Same. Not high.
The Learned Trial Court found them guilty under section 498A, 304B, 201 by 34. 302 charge, he was not found guilty.
No.
What is your statement, accused statement? How she sustained burn injuries? ଖାଲି ନାଇଁ ନାଇଁ କହିଛନ୍ତି। ଆପଣଙ୍କର ସ୍ତ୍ରୀ ବା ଆପଣଙ୍କର ବୋହୂ ଆପଣଙ୍କ ପାଖରେ ରହୁଥିଲା, ସେ ପୋଡ଼ି ହେଇ ମଲା ଏବଂ ଡାକ୍ତର ରିପୋର୍ଟ ହଉଛି ପୋଡ଼ି ହେଇକିରି ମଲା ବୋଲି। And he has sustained 90% burn injuries. Kerosene smell was also coming from his body. What is your explanation? And these two witnesses, PW12, who is the father and brother, they have stated that at the time of marriage, there was a demand of dowry, and after 4 days before her death, he has come to the father's place and told that the accused persons were insisting on payment of rupees 50,000. And the father expressed helplessness that he could not pay further dowry. ତାପରେ death ହେଇଛି ଏବଂ intimation has been given. All right. IA number, IA number 331 of 2025. There is an application filed by all the three appellants. Appellant number 1, Nanda Malik, who is about 71 years. 71 years could file it?
My lord, occurrence ବେଳେ 64 ହେଇଛି। 74 ଏବେ।
Judgment ରେ ଦିଆ ହେଇଛି, let us say judgment ନାଇଁ, accused statement ଦେଖିଲି। accused statement ତା ନିଜ ଏଜ୍ କେତେ ଯୋଉ 54।
54। 10 years।
ଶଶୁର ନାଁ ହେଲା 64 years. ଆପଣ 64 years କହିଲେ କେବେ ନା 2018 ରେ
11/3/2015
ଏଇଟା ବାହାର କରନ୍ତୁ। ନାଇଁ their petition is stated to be aged about 71 years and is the father-in-law. Appellant number 2, Saudamini Malik, who is aged about 61 years, is the mother-in-law. And appellant number 3, Prafas Malik, is the husband. Though faced trial in the trial court for commission of offences under section 498A, 304B, 302, 201/30 Code of the Indian Penal Code and section 4 of Dowry Prohibition Act. But the Learning Trial Court found them guilty under section 498A, 304B, 201/34 of Indian Penal Code. And further held that the charge under section 302/34 IPC has not been proved against the appellants. Learned counsel for the appellants submit that the appellant number 1 and 2 have remained in custody for more than 8 years, and appellant number 3 has remained in custody for more than 10 years. And it's a case based on circumstantial evidence and there is no chance of early hearing, and therefore the bail application may be favorably considered. Learned counsel for the state, on the other hand, produced the custody certificate, which also indicates that the custody periods of appellants number 1 and 2 were more than 8 years. And so far as the appellant number 3 is concerned, it is more than 10 years. He has also produced the jail conduct of all the 3 appellants, which indicates that their behavior inside the jail is polite, faithful, and the learned counsel for the state has also obtained instruction from the jail superintendent that the appellant number 1, the father-in-law, is suffering from kidney disease, and the mother-in-law is suffering from hypothyroid. Stop. The documents produced by the learned counsel for the state are taken on record. It is argued by the learned counsel for the state that the marriage between the deceased and the appellant number 3 took place on 11/3/2015, and she died on 13/5/2015, about 2 months after her marriage. And PW 14 is conducted post-mortem examination has noticed 90% burn injuries on different parts of the body and opined that the cause of death was due to shock on account of excessive burn. He further argued that brother of the deceased, who is the informant in the case, has been examined as PW10 and father of the deceased has been examined as PW12. And they have stated about the demand of dowry not only at the time of marriage but after marriage, which was informed to them by the deceased. He further submits that even though the deceased was staying with the appellants in her matrimonial house and she suffered burn injuries and kerosene smell was emitting from the body. But in the accused statement, the appellants have not stated, given any explanation as to how the deceased sustained burn injuries and died. When counsel submits that in view of the materials available on record, the appellant should not be granted bail. Considering the submission made by the London Council for the parties and in view of the available material on record, we are not inclined to grant bail to what is that jail criminal of the appellant number 3, Prakash Malik, and accordingly his bail application stands rejected. So far as the appellants number 1 and 2, who are the parents-in-laws of the deceased, are concerned, taking into account their age, their period of detention in judicial custody, their ailments, and absence of any chance of early hearing, so also their jail conduct, we are inclined to release them on bail. Yes, next.
Item 9.
Yes, item number 9. Prisoner's petition at flag G. Ronachi.
May I please write?
Yes,
Item 9.
wait, please. For G. Yes.
Item 9, IA 359 permitted to withdraw.
IA number 359 of 2025. This is an application for bail. What is your good name?
Akshay Kumar Sahu.
Huh?
Akshay Kumar Sahu.
Mr. Akshay Kumar Sahu. आपको तो पावर नहीं है देने?
प्रथम अच्छी
Akshay
not
Kumar
reflected but also power.
sign କରିଛନ୍ତି वकालत
Sign
ना?
ନାହିଁ।
Let us see that वकालत now. ତା ପୂର୍ବର ଓକାଲତନାମା ଓକାଲତନାମା ନାଇଁ ଓକାଲତନାମା ଥିଲି ଆପଣ ପାୱାର ନାହିଁ ତ୍ରିଲୋଚନ ନନ୍ଦ ବିକେ ପଣ୍ଡା ପ୍ରଥମେ ବେଲ୍ ଫାଇଲ ଏଇ ଯୋଉ ଓକାଲତନାମା ଫାଇଲ କଲେ ତାପରେ ଓକାଲତନାମା ଫାଇଲ ହେଲେ ଏସି ଷଡଙ୍ଗୀ ଏକେ ଷଡଙ୍ଗୀ ଟି ଷଡଙ୍ଗୀ ବାସ୍ ସେତିକି ତିନିଟା ନାଁ ଅଛି
I have signed whenever the power.
Have you filed Wakalatnama?
Yes, ma'am.
ସେପାରେଟ ଓକାଲତନାମା
It's suddenly
Along with
Ekes
Huh?
there is no which matter you are this is item number 9 jail criminal appeal 98 of 2019 Sukadev Behra you have got
I
no
have
power
also moved today. I released the person 3 months. In the order dated 1/10/24, I have already released the accused person before unlocked in 3 months. Interim bail.
1/9/2024
1/10/2024.
हाँ ये तो एसी षडंगी को ना लिखा है
On behalf of starting
interim bail is granted.
yes,
what do you want now you want to withdraw this
Withdraw.
अच्छा I number so and so land counsel for the खाली appellant ना लिखो तुम does not want to press this application disposed of as not pressed yes
My lord, name of Trilochan Nanda and BK Panda may be deleted, my lord.
अच्छा since the newly engaged counsel Mr. S.C. Sarangi and his associates have entered appearance the names of Mr. Trilochan Nanda and B.K. Panda shall not be reflected in the cause list henceforth. Yes.
Item 10.
Met with the lordship. Last time is conduct, history and previous problem.
Yes.
Conduct and antecedent custody period was called for.
You got it?
Mr. Mohanty, have you received it? Yes. What are the materials?
I would say, sir, there are 1, 2, 3, 4. We took 1 term of time. And 2, 3, 4 are stated to the chance witnesses,
Not here to do.
and they didn't disclose anybody. Only the brother of the deceased lodged FIR.
Accused reached there being armed with a tangia and dealt 3 blows on the blunt side to Sebov. So that is stated by 2, that is stated by 3, and that is also stated by 4. And who is the doctor?
Doctor is my lord
17. PW 17. So he has noticed lacerated wound on the posterior part of the head. Another wound also on the head. Occipital bone, right parietal bone, right temporal bone, all these are fractures. Cause of death due to intracerebral hemorrhage and due to traumatic head injury caused by blunt object. homicidal death. What is his criminal antecedent?
See, that has to obtain only because you look a custody certificate obtained because there is a transfer in the meantime from what to God.
No, this, and about that he has to be obtained from the
IAS,
IAC, not from the jail superintendent.
That is it.
Superintendent has
Hanpa
already
police
given
station.
that it is a satisfactory.
Hanpa police station as called for next week.
It is in the page 144, madam. There is no CA.
Counsel for the state has produced the custody certificate. So also the jail conduct report of the appellant, which are taken on record. However, he seeks for an adjournment to produce the instruction regarding criminal anti-slavery training of this matter on the 1st of December 2027.
May submit, madam. It is reflected in the CD, madam. 144 page. No CA.
Just like A number so and so stay relation of fine allowed.
Obvious.
Item 11.
Let's say jail criminal appeal.
Prisoner's petition has come for engagement of advocate S.S. Roy in place of S. Panda. Acha. Period the prisoner's petition dated 26/2025, in which a prayer has been made to engage Mr. S.S. Roy too as his advocate. Mr. Roy has already filed wakalatnama. The name of the other counsel shall not be reflected in the cause list henceforth. What about that IA?
My lord, I have filed one IA for bail, my lord.
How many years?
My lord, custody since 18/6/2021. Today I am serving the copy of the depositions to the State Council. Lordship may call.
The Lieutenant Counsel for the
Just now, just now,
appellant has the deposition copies on the Lieutenant Counsel for the state today in court, and Lieutenant Counsel for the state is for an agenda.
Here is there are three criminal antecedents that I am suffering. That may take.
The Lieutenant Counsel for the state has produced written instruction regarding 3 criminal antecedents against the appellant, and the claim is taken on record. Mr. Roy shall obtain instruction regarding the status of the 3 cases and file a comprehensive affidavit in that respect. This is taken on record.
তিনটা জায়গার নম্বর আছে আপনার পাশে দেই দিন
The name of Mr. Devashish.
We have already.
You will also may call for the custody certificate, man.
Custody certificate pathina anna ji.
No, custody and conduct.
So custody certificate and jail conduct to be produced.
Please.
Next item 12.
Item 12.
Yes, Miss Mehta.
Well, the charges are 498 and 302. Now, in view of the post-mortem report and the evidence of PW7, 302 is not made out. Death is due to poisoning. 498, now the period in which for which I am in custody, that is from 19/12/2022. Allowing for remissions, I have completed the entire period of my maximum sentence under 498.
You have been found guilty under what offense?
498 and 302. The Lordship may see the paper book at page 78 belows.
Who is the doctor?
PW7, Dr. Purnima Singh. The evidence begins at page 75. My lords may see paragraph 2 first. The injuries.
Finding is that it is a homicidal death.
Oh, your lords, you may first look at the injuries. Therefore, I am saying at page 75.
Nail scratch injury.
During my examination, I found following external injuries. Multiple nail scratch abrasion, size 1 into 0.2 cm, just above areola of left breast. Similar multiple nail scratch abrasions, 0.3 into 0.3 cm, present over the upper chest towards the
Mr. Devasis Pandal and Counsel for the appellant submits that in view of the C report finding, as well as the opinion of the doctor bracket with PW7, that the cause of death was due to organophosphorus poisoning and complications thereof. The findings arrived at by the London trial that the death of the deceased was homicidal, mainly on the ground that some injuries were sustained by the deceased, which is not relatable to the cause of death, is not acceptable. The London Council for the state seeks some time to examine if other materials are available on record to justify a conviction under section 302 IPC. Release this matter on 21st November 2025. Yes.
Can I pray your lordship may add one more thing? ये जो क्वेश्चन टा होमिसाइडल बोले डॉक्टर कहछि सेटा भी 313 रे पचरा है एटा भी
Will examine that is there. Yes,
check whether this is put to him or not.
The matter of theoretical base. And once another thing is that suppose the alternative charge has not been framed. In this case, suppose 302 read with 304B or 306 that has not been framed. So if you could have framed the charge, you would have defended accordingly. So once you are not framing those charges, can this court alter the conviction direct from 302 to either 304B or 306? Let us say.
It cannot be at all, Lords, because there is no evidence.
Rebuttable presumption operates against him. Unless the charge is framed, how can he rebut it?
So there is no other alternative charge. All right, next.
Item 13.
My lord, an IA has filed for bail. My lord, an IA has filed for bail. The Learned Section Judge Mayurbhanj Baripada.
What is the offense, madam?
Offense under section 302 of IPC.
498A 302.
As acquitted.
And you have been acquitted under 498A.
Yes, my lord.
Only found guilty under 302.
302.
And what is the doctor's report, PM report?
PW 14, my lord.
Yes, sir. Number of injuries.
14.
14 injuries. So how many injuries you have caused? 14 injuries. 14 inside wound you have caused. So you are the husband.
Yes, my lord.
And the cause of death has been opined due to
By means
injury to the abdomen and chest. And sees your wife staying with you, and the external injury number 11. 11 and 13 penetrate the chest and perforate the left lung with left hemiothorax. External injury number 13 penetrates the abdominal cavity and perforates liver with hemoperitoneum. External injury number 14 penetrates abdominal cavity. So very inhumanly you have committed the murder.
Period.
How much period?
My lord, 7 years, 11 months, 28 days.
After February 2026, stay of realization of fine allowed. Yes, next.
Item 14.
Lord, the appellant number 1 has already engaged a new counsel by prisoner's petition. Lord, our name Tanmay Mishra and associates kindly be omitted, my lord.
Prisoner's petition is that dated 13/10/25 से बात कर लो.
Yeah.
Satyanarayan Mishra 4. Have you signed you?
I'm not
going to sign it. The prisoner's petition has been received from. This is the sole appellant or number of appellant?
2, my lord, appellant 1 and 2. 2 is on bail. Father and son.
Appellant number 1 also Kahas for engagement of Mr. Satyanarayan Mishra as his advocate. Mr. Mishra is present and the Wakalatnama has been sent along with the prisoner's petition. Let Mr. Mishra be permitted to fill up the Wakalatnama and file the same. The name of, but so far as the number 2 is concerned, the other counsel name shall continue. Why you are appearing only for appellant number 1?
Yes.
What is your the names of the advocates?
Tanmay Mishra,
Acha.
Biswa Mishra, and
That was only for appellant number 1.
Yes.
Acha. Since for appellant number 1, the newly engaged counsel has been new counsel has been engaged. The name of Mr. Tanmay Mishra and his associates shall not be reflected in the cause list henceforth. Baki, what about the bail of? So you file a fresh bail application because
one bail application is pending, my lord, in custody since last 17 years.
Which is pending? 2018.
But it has been rejected 4 times. Last I is pending in 1925.
Have you got that custody certificate? No. or have you stated that he is in custody for 17 years? Where from you got that information?
Is arrested on 18/2/2008.
He was not released on bail.
Only once released on follow on 21/12/2015 to 3/1/2015.
Okay. IA number 1925 of 2000.
Sorry.
Huh?
It is in the IA.
What IA?
3/9/17 it is reflected.
On that?
397/2017 IA. It is reflected in
There is no 397. This is IA that is pending here.
What he said in that application, it is reflecting 17.
397 it is reflected in custody and religion follow for only 12 days.
Okay.
It's all-
That has already been disposed of.
Oh, that we are now considering 1925. Look on IA number 1925 of 2018. This is an application bail filed by appellant number 1, Ashok Pahar. Grounds has been taken that he is in judicial custody from the date of his arrest, that is 18/7/2008. Stop. The London Council for the date seeks some time to obtain the custody certificate. He is now in Fulbani jail.
One more thing I may propose to notice, my lord.
On 1st of December 2025. Yes.
I have been engaged in one case for the premature release of one convict. In that list, this person name is there.
Okay. He might have been
premature release. That is a reject.
Rejected.
Yes.
Achha, he is premature release rejected.
Ashok Kumar. Ashok
Kahar.
Rejected the almost. Another instruction. Next.
Item 15.
Okay. For which maybe.
Mr. Mishra be permitted to take a paper book or be supplied with a copy. Paper copy. Yes.
May I please will Since 18/6/2014, the appellant is in custody for the offence under section 30234 of the Indian Penal Code.
Just a minute.
And
have you received the custody certificate? No. Have you got the custody certificate?
Custody called for.
There is already order.
There is called for by a letter dated 22/8/2025.
The London Council for the State seeks some more time to comply the order dated.
They are perhaps they are in different form perhaps that is produced. अलग फॉर्म में
मैंने फॉर्म की जाओ अपन तो फाइल करना जे अछि दिन आमे तीनटा जिंस मागिथिलु गोटे होची कस्टडी सर्टिफिकेट गोटे क्रिमिनल एंटीसीडेंट आ गोटे होची कंडक्ट ऑफ द पिटिशनर इन जेल एटा कोन दे
कस्टडी ता पर ओटा
एटा रखिथन कि हम फाइल करना दी एटा सुआंसो एटा कोन हला he was transferred to it. If you want to code transfer along.
August month.
August month. Took some time to obtain the comparative, to obtain the litigant custody certificate, criminal antecedent, and jail conduct certificate. Bit of this matter on 1st of December 2025. Yes.
Item 16.
Yes, my lord. My lord, here the petitioner is languishing in jail custody near about 13 years. Since 29/3/2013, he is in custody. My lord also granted interim bail for 3 months.
When?
And
when?
My lord, that
19/6/2020.
Yes. I have surrender certificate also I have given.
You have filed another bail application.
Yes.
After surrender.
Yes.
What is that number? Is it 2735?
Sir.
What is the conduct file on interim bail?
That conduct that to obtain we have issued letter on it next week.
Acha. Lekhandu, IN number 2735 of 2025. Mr. Niranjan Panda, Land Council, appearing for the appellant, submits that as per the order dated 19/6/2025, the petitioner was granted interim bail for a period of 3 months. And after availing the same, the petitioner has surrendered at right time. Stop. Land Council for the state seeks for an adjournment till next week to obtain the report from the IIC Fulbani Sadar Police Station regarding the conduct of the petitioner while on interim. Place this matter on external for them. 1/12/2025.
Item 17.
Yes, the appellant is a lady in custody for about last 10 years.
There are two appeals, Mr. Chan.
My super criminal appeal 653 is concerned. There I have filed a
In other case, also an interim application has been filed for bail.
Here,
you are now moving only for this lady.
So super 653 is concerned bail. Bail application.
ଦିଟା ଆଗରେ ବେଲ୍ ଅଛି
ଆଜ୍ଞା ଏଥିରେ ଗୋଟେ ଦିଟା
ହଁ ତେଣୁ ଆପଣ ଆଜି
ଦିଟା
ମୁଭ୍ କରିବାକୁ ଚାହୁଁଛନ୍ତି
653 653
alright 653 oh ଠିକ ଅଛି so this petitioner is a lady Manorama Jena and she has been found guilty under section
302 34 and 498
mother-in-law. What is the age of this?
She was 52 years by then. Now my lord, 10 years, 62, around 61.
Fifty-two ଥିଲା 2017 judgment ହେଇଛି so 8 ବର୍ଷ add ହେଇଗଲେ 60 ହେଇଯିବ and what is the how the deceased died?
As for the prosecution case, dying declaration is there.
No, what is the cause of death?
Cause is that it is alleged that there are some marriage was about 8 years before.
Cause of death man as per PM report.
I know. Cause of death that is because of burning. Right. The
doctor?
4 doctors are there. Initial doctor is who has treated. Preliminary doctor is PW5.
No, the doctor who conducted PM.
PM. It is PW14 madam.
Dead body of Swanto. Acha. Born injury 70-75%. And cause of death is born injury. And before whom this dying declaration has
2 dying declarations are already required. One is before my lord PW10.
Written or oral?
One my lord written.
So who has
PW10 and PW13, PW10 and PW12 my lord. Both are claiming to the doctor.
So they are the doctors who recorded the dying declaration. Okay, that is being marked as
PW Exhibit 8 and Exhibit 11. Exhibit 11 is the better ticket where this has been reflected, and Exhibit 8 is a separate signal. And both where it is alleged that the father is also present.
Tomorrow namo ঠিকনা কোন মধুমিতা মুদুলি স্বামী সোয়াংশু আছে তোমার দেহ কিপরি পড়িলা গত বুধবার দিন ପ୍ରାୟ 12:30 ବେଳେ ମୋର ଶ୍ୱଶୁର ମୋ ପାଟିର ଲୁଗା ପୁରାଇ ଦେଲା ଶାଶୁ ମୋର 2 ହାତକୁ ଧରିଲା ନଣନ୍ଦ ଗୋଡ଼ ଧରିବା ପରେ ନଣନ୍ଦେଇ ମୋ ଉପରେ କେରୋସିନ ଢାଳିଲା ଏବଂ ମୋ ସ୍ୱାମୀ ଦିଆସିଲି ଲଗାଇ ମୋ ଦେହରେ ନିଆଁ ଲଗାଇ ଦେଲା ମୁଁ ଜଳୁଥିଲା ବେଳେ ସେମାନେ ବାହାରକୁ ଯାଇ କବାଟ ଦେଇଦେଲେ ଘରେ ମୋର ଦାଦା କବାଟ ଭାଙ୍ଗି ଘରେ ପଶିଲେ ତାପରେ ମୁଁ କିଛି ଜାଣିପାରିଲି ନାହିଁ ମୋର ଏ ଅବସ୍ଥା ପାଇଁ ମୋର ସ୍ୱାମୀ ଶାଶୁ ଶ୍ୱଶୁର ନଣନ୍ଦ ନଣନ୍ଦୀ ଭାଇ ଏଇଟା ହେଲା ଏକ୍ସିବିଟ୍ 8 ବାକି ହଉଛି ଗୋଟେ ଏକ୍ସିବିଟ୍
11 ରେ better ticket.
Exhibit 11 बार करो
There could be another doctor, period 12.
हाँ तुम नाम कौन सुहांशु ଠିକଣା ହେଲା ତୁମର ପୋଡିଯିବାର ସର୍ଭେ ପୋଡିଯିବାର କାରଣ କଣ? ଯୁକ୍ତିକାନ୍ତ ସୁହାଂଶୁ କିରୋସିନ ଢାଳି ମୋ ଦେହରେ ନିଆଁ ଲଗାଇଦେଲେ। ତୁମର ଏଇ ସାଂଘାତିକ ଅବସ୍ଥା ପାଇଁ କିଏ ଦାୟୀ? ସ୍ୱାମୀ ଶାଶୁ ଭିଣୋଇ ଶ୍ୱଶୁର ମୋ ଦେହରେ ଢାଳିଦେଲେ। ଅଛି ତ ନାଁ ଅଛି?
Name is there. So, but my let me take note of this aspect that the father was also present very much. He was very much present.
ठीक so what father माने जो ଶ୍ୱଶୁର
हाँ, झियोर बापा.
ବାପା
And it is also the further case in the prosecution when the things were there. That means before a day there was some quarrel between the two families, and to settle the same, the father had to.
We are not appreciating now this. We are not hearing the final.
Yes, but that's why.
So we just wanted that your name is there or not in the.
Yes, that is there. That is there.
So if that is there, what is your period of detention?
10 or so. You are 15 The exact date is minutes. I am in custody from 11.
Where is that custody certificate?
What, 8 years?
8 years.
8 years, 3 months. 15/11/2025 ରେ ଆସିବ।
हाँ। My friend is perhaps taking note of the other aspect. I am in custody from 26/11/2015.
ଦେଖାଇ ତାদের ଲେଖାଇ ଦିଅ।
ଆଜ୍ଞା ଠିକ ଅଛି।
custody certificate। ବେଲ ଫେଲ ଯାଇଥିବେ ଯଦି ସେଟା
ବେଲ ବୋଧେ ଯାଇନି ଆଜ୍ଞା।
କି କୁଆଡେ ଯୋଉ କରୋନା ପିରିୟଡ ରେ ସବୁ
ହଁ ସେଇ ପିରିୟଡ ରେ
26/11/2015 ଠିକ ତ ଅଛି।
ହଁ 26/11/2015
25/9/2017 ଆଚ୍ଛା ହଁ ଫୋରଲଙ୍ଗ ରେ ଆପଣ ଯାଇଥିଲେ ପରା କୋଭିଡ ରେ 2021 ଜୁନ ରୁ 2023 ମାର୍ଚ୍ଚ ପର୍ଯ୍ୟନ୍ତ ସେ ପିରିୟଡ ଟା ଏକ୍ସକ୍ଲୁଡ କଲାଠୁ 8 ବର୍ଷ 3 ମାସ ହଉଛି ଠିକ ଅଛି। तो बाकी की काउ कन्विक्शन ହେଇଛି?
all family members, all father-in-law, mother-in-law, that
ଏଇ ଯୋଉ ଆପଣ
brother-in-law,
CRL 653 ରେ କି appellant କିଏ?
ସିଏ ହଉଛନ୍ତି ଆଜ୍ଞା ତାଙ୍କର ମାନେ ଜୋଇଁ
ମନୋରମା
ନାଇଁ 54 ରେ join 53 ରେ dispute
53 ହଉଛି the
No, we are
mother-in-law.
considering only this 653 of 2007.
Yes, sir.
Which indicates that you are 8 years and 3 months.
Monorama and Jeevan, husband and mother-in-law.
conduct us.
Is an application of the Grand Council for the State for the chief of police and state. This is dated 15/10/2025, on which it appears that the plan was followed with the case and period. It will take 13/6/21 to SBA in 2020. Study. Contract on the
Item 18.
Yeah, that's to take the evidence copy of the petition so that can be taken support. Perfect certificate, perfect certificate. 11 वर्ष 18 मास 21 दिन, including remission. Including remission.
302.
302.
Sole appellant, my lord. Yes, my lord. Son of the deceased, my lord. PW9, my lord. Actually, my lord, I would not exactly I would miss, but
Dying declaration exhibit 2
my lord.
8, 9, 10.
8 is not I would miss, my lord. My lord, occurrence actually, my lord, 6/12/2013, and FIR was lost.
I pray
on
to next week and may allowed to take the
18/12
deposition so that it
after 7 days of occurrence, my lord. My lord, mother and 2 daughters, my lord.
deposition. Deposition. Again. If the paper book is ready, I may allow to take so that it will be. Again.
Yes, my lord. And the last time, my lord, your lordship has called for the custody certificate.
That has.
Like it has.
Item 19.
Lordship pass out. On behalf of Mr. Next.
Item 20.
Custody for more than 11 years. Last occasion. Subsequently, notice
They want engagement of a legal aid counselor. Yes. Original वकालत.
Item 21. 21, may I please your lordship? My lord, in this matter, the present petitioner is examining inside custody since 14/7/2014, my lord. And on earlier occasion, he released on interim bail and the surrender 3 months and surrender. The date of surrender as per the report that is 13/8/2020.
I've already.
My lord, he surrendered one day after, right? So there is a good present.
The state has will be released to receive case does not know the options. If it 1970 so that we being found consistent with the other end. Why you are granted
My lord, he is inside custody for 11 years. Considering the judgment of late, he is granted for. I can.
this petitioner this was and there's nothing civilized them when the
There are eyewitnesses and dying declaration is there.
that principle here.
Yes.
Yes. He has not civilized.
Yes, sir.
Understand he has been on this problem.
Yes. Yes, Azir. Yes.
Again, paragraph 25 interim bill, item 20.
तो बॉडी जो
ପଛୁ ପୁଣି ଆସ ଏକ୍ସାମ ଦେବାକୁ ଲଗେଇ ବସୁଛୁ ଲାଷ୍ଟ ବେଳକୁ ପୁଣି
29 ରହୁଛି 40 ହେଇଯାଉଛି ପୁଣି 25 interim bill ମାନେ 25 ଟା ଝିଅର ମ୍ୟାରେଜ ଡଟର୍ସ ମ୍ୟାରେଜ
minor.
5
45.
There's an application for green leaf on the ground of marriage of the daughter of the petitioner, which is going to be solemnized on 25th November 2025. The Land and Council for the state has obtained the instruction from IIC Itamati Police Station dated 18/11/2025, which also shows that the marriage of the daughter is going to be solemnized on 25/11/25. The written instruction is taken into of the government statement and the report of it is granted interim bill for a period of 4 weeks. So now, as while on interim bill, we shall not indulge in any criminal activity, and shall not try to come in contact with the 302 cases. Try to come in contact with the family members of the business. Violation of any terms and conditions or until cancellation of the.
small pair posted the copy of all of
You will get it.
Minus I. Ready for it.